Background music.
Oh, okay. It sounds like me.
LT, is everybody in?
I am checking, Chief Justice. Our registrar clerk is ready and we have started live streaming. Our registrar clerk may proceed, Chief Justice.
Good morning. I am the registrar clerk hearing. Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Minister of Water and Sanitation and Sembcorp Caesar Water Pty Limited. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the justices, I am Homotso Moroka for the applicant, together with my juniors, Mr. Happy Mche and Ms. Malebu Moropa, instructed by the State Attorney.
Thank you, Ms. Moroka.
Chief Justice and Justices, my name is Kemp, first name also, and I'm appearing with my learned friend, Butterfin Jones, and instructed by the firm of Cox Yates. And we appear for the first respondent.
Thank you, Mr.
Colleague in Bousfield, sorry. I lost my location here, Chief Justice.
Thank you. Thank you, Mr. Kemp.
Mr. Chief Justice and the justices of the court, I appear together with my learned friends, Mahabir SC, Mfega, and Pama for the second respondent.
Thank you, Mr. Madonsela. As I understand it, you're going to go first.
Yes, Chief Justice, if I may.
And you need your 10 minutes without interruption.
Thank you, Chief Justice.
Thank you.
This case engages the constitutional jurisdiction of the court. From the very word go, it was structured along those frontiers. In the affidavits which are set out at page 129, paragraph 18, page 132, paragraph 20.3, page 150, paragraph 53, the case was structured along the lines that the power of the Umgeni Water Board to regulate tariffs or to impose tariffs in the manner that it did in this case was a measure taken to ensure that the citizens in the KZN or those who are serviced by Umgeni Water Board have access to water as envisaged in section 27, bracket 2 of the Constitution. The only redeeming feature of the SCA judgment is that in paragraph 1, the SCA recognizes this constitutional context of the case because it refers directly to the provisions of section 27(2) of the Constitution as affecting, or rather as being the platform on which this case is to be viewed. So we submit very shortly that on that practical basis, on that basis that is set out already in the pleadings in this case, a constitutional case, a constitutional jurisdiction of this case is directly engaged. The case involves what we call quintessential constitutional matters, or is concerned with constitutional matters which are foreshadowed in section 27 of the Constitution. And secondly, the extent to which the courts below have sought to interpret, or rather to constrain the power of the Umgeni Water Board to exercise this power does not only implicate the narrow interests of Umgeni and the litigants in this case, it has got a broader impact on other water customers like the municipalities who, as we have explained in the affidavit, have been complaining about the equity of having to subsidize the tariffs in relation to Caesar Water in circumstances where Caesar is a commercial entity. So the matter is one of general public importance on whether Umgeni can really differentiate between its customers or whether it should be straitjacketed into imposing a uniform tariff throughout all of its customers. And thirdly, we say that the matter in any event is one of that must be entertained by this court under the rubric of the interests of justice. And the interests of justice are somewhat interwoven or mixed up with the merits of the appeal, which we deal with later on. We submit on that level that, as we will demonstrate when dealing with the merits, that the appeal, the contemplated appeal in any event, has got good prospects of success. So that puts us into the jurisdiction of the court, therefore, and therefore we submit that the court has jurisdiction to hear the matter. And that application for leave to appeal, albeit at the instance of the minister, should be granted. And the question of mootness has been raised in the papers, and it has been addressed in the context of what has happened between the SCA delivering its judgment, as well as this court dismissing Umgeni Water's leave to appeal. It has been suggested that an annexure which is found at page 1088 serves to settle the dispute. We ask the question in that context: if SM2 is capable of being construed as a settlement agreement, what is it that it was actually settling if the litigation between Umgeni and the Caesar Water had been finally determined by this court? We submit that the logic of the argument fails, because if the matter was indeed finalized by the court on the 5th of February, when the application for leave to appeal of Umgeni was dismissed, then there was really nothing to settle, because SM2 was really to give effect to that termination of the proceedings by the judgment of this court, under the pain, as it were, of the judgment of this court. So it cannot lie in the mouth of Caesar to suggest that that document, SM2, was a settlement agreement. But in any event, on its terms, and we have explained this in the affidavit, supplementary affidavit, that on its terms, that document is not a settlement that is capable of extinguishing any live dispute between the parties. All that it was an accounting exercise to pass a credit and account for the monies which were held, or the debt which was raised by Umgeni against the municipality under the pain of an order of this court dismissing its leave to appeal. So in our submission is that we submit that that document cannot be construed as a settlement at all. But even if we are wrong about that, we would have seen in the affidavits, in the supplementary affidavit, or rather in the answering affidavit opposing leave to appeal, at page 112, paragraph 36, that's the Caesar's approach to the monies which were held in trust by Gallic and Bosfield, Pendente Lite, is monies which have been transferred to Caesar and to be dealt with in the way that Ilembe municipality or Ilembe district municipality is to regard them when they formulate their tariffs between Caesar and Ilembe. So at the practical level, those funds are still lying in the account of Caesar, pending Ilembe's decision about it. So it is that situation has not arisen. We are not there yet. We are now in court dealing with the matter involving the minister concerning those very tariffs which were levied by Caesar to the members of the public, which are still kept to be dealt with by Ilembe. So practically, the fate of those funds in our submission can very well be determined by this court in the context of this application, because Ilembe has not dealt with those funds in any other way. Of course, as a backstop approach to litigation, we have obviously mounted a conditional application and we seek that's the settlement agreement. If it is a settlement agreement, should be set aside by the court exercising its first and final jurisdiction, direct access. And we emphasize in our heads of argument that it's probably not necessary for the court to reach that far, because on the construction of the settlement agreement, it is not a settlement agreement. But if, as a backstop approach, we have adopted the stance that if the court is not with us, that it's not a settlement, then it must directly deal with settlement and set it aside for the reasons that we have advanced. You would recall that in the affidavit we explained that when the funds were, when the credit was passed in favor of Caesar, it was under the misapprehension that the minister's leave to appeal also had been decided. But the respondent, the first respondent, knew that that litigation was still pending before the justices. And the registrar of this court had indicated to them that the matter was still pending. So it was under those circumstances that Umgeni passed a credit, oblivious of the fact that the litigation was still ongoing. So we submit that that settlement, if it was a settlement, was obtained under circumstances where there was material non-disclosure of the fact that the minister's appeal was pending before this court. So in short, we submit that the matter is not moot and that this court should exercise its constitutional jurisdiction regarding the merits of the appeal. I did not touch on the issue of res judicata, which was raised in the papers, because it has not been pursued by Caesar in their heads of argument. But if it becomes an issue, I can then deal with it in reply. But as we've pointed out, in the context of res judicata, the matter is not res judicata because the minister has brought its own application asserting its own reasons why an application for leave to appeal should not be granted. But of course, as a backstop, again, as a backstop approach, we have submitted that the court is in any event at large under the inherent power in section 173 to revisit its decision in relation to the dismissal of Umgeni Water appeal. Again, as a court of first, of course, because the court is already seized with the matter. And we have grounded that application on the apprehension that it may very well be, and we say this with all respect, it may very well be that this court made an error when it dismissed Umgeni's application for leave to appeal. But we simply don't know, because the summary nature in which applications for leave to appeal are entertained by the court makes it impossible for litigants to know with certainty what the reasons were or the underlying reasons were for the dismissal of the leave to appeal. We think that we are confident from what happened at the time when the application for leave to appeal the order was granted, and the errors which took place at that time, that it may very well be a human error. But if we are wrong about that, then the court then does not need to deal with the application for recollection. But if we are right, we are confident in you've brought the application for recollection of our leave to appeal on the basis that the court, if it knows from the proceedings that took place in camera or in its deliberations that there was an error about Umgeni's application for leave to appeal, that the court will do the right thing and recall the order and deal with the matter of the application for leave to appeal brought by Umgeni. But again,
well, your 10 minutes has expired, Mr. Madensela.
yes.
You may proceed, but I'm just alerting you to the fact that colleagues may put questions to you from now on.
Yes. Well, on the merits, we make 5 points. One, we say that the policy of Umgeni allows the differentiation for tariff purposes. And this is because clause 21 of the policy espouse a cost recovery regime, which is dependent on the assessment of a business unit, a scheme, such as the one that CESA was. Secondly, we say that the term cross-subsidization was misunderstood or misconstrued by the SCA. That term was used in its bookkeeping, in a bookkeeping nomenclature to understand how CESA, how Umgeni, accounts for each and every scheme in its own books and how other schemes are cross-subsidizing the other schemes. So the SCA got it wrong insofar as interpreted concept cross-subsidization. That also led to it not understanding what the process of eliminating cross-subsidization involves. Thirdly, we say that CESA does not perform an inline function on behalf of Ilembe municipality. It is a purely commercial entity, and the findings by the SCA that the fact that it was a private entity was an irrelevant consideration conflates the issues. It conflates firstly, it conflates the standard of review. If it was an irrelevant consideration, then the issue should not have been what the SCA posed it to be. It should not have been the issue, the case was about the rationality of imposing tariffs that Umgeni performed. Because rationality is not concerned with irrelevant considerations. And I think it's Justice Jafta in the judgment of PG Groups who makes the point that when we talk about irrelevant consideration, that is a self-standing review ground under PAJA and does not feature at all in relation to a rationality inquiry. So the SCA conflated the issues at that level. But even if we were to accept that the matter is to be addressed or to be assessed on the platform of PAJA, we say in any event that the SCA misconstrued or did not take into account the relevant consideration, which was that CESA was differently placed compared to other municipal customers. And therefore, there was a basis for a differentiation on that basis, even on an administrative law or PAJA basis. And finally, the SCA, the fourth point, the SCA did not take into account the justification that was given by Umgeni for separate treatment of CESA, because the SCA, it was explained in the affidavit that CESA was differently placed because it was sourcing water from one source and could not be assisted in terms of offsetting its own costs against other schemes that it operates. Finally, we debunk the notion that the Umgeni Water Board took into account ex post facto rationalization of a bad decision. And we make reference to the affidavit why that issue cannot arise in this case. And we make reference to, in particular, page 75 and 76 of the document which was sent to CESA to explain why it was being treated differently. And that explanation involves an assertion by Umgeni that CESA could not be dealt with in the same way as the other entities because it was sourcing water from a singular source and it could not be assisted in terms of offsetting its costs against the revenue. So in
Mr. Madonsela, Mr. Madonsela, excuse me.
Yes.
Excuse me, if you can allow me. Why do you say CESA does not perform online function for Ilembe? I was under the impression that they were actually acting for Ilembe in respect of the water services. Can you just explain that to us, please?
Yes, the CESA receives bulk water from Umgeni and distributed to members of to the customers within the concession area. And insofar as that function is concerned, it does so in terms of the bulk water services agreement. And in relation to that bulk water services agreement, it allows it to receive water from Umgeni on behalf of its customers and then reticulate it under the concession agreement. Now, what the SCA said about this was that, well, we don't have to enter into, to understand, to characterize the relationship between CESA and Umngeni under this concession agreement as well as the tripartite agreement. Because that exercise would have revealed in our submission that CESA was just not a purely inline function, but it was a commercial entity making money out of the business of selling water to its customers. And that is...
Mr. Madonsela, sorry, can I interpose a question on that very point that you're making?
Yes.
It is clear from Section 19 of the Water Services Act that the Water Services Authority may enter into a written agreement with the water service provider. Now, you say that that is not an inline function, but what other function is it performing when it is reticulating water on behalf of Ilembe? That's the first question. And then just to touch on, you say the SCA erred on the question of them not regarding that as that the status question was irrelevant. Clearly, CESA is a mandatory of Ilembe. You cannot extricate that relationship. It is an integrated relationship. It is performing a function on behalf of Ilembe. On what basis then is it rational to treat it differently? Simply because it's a commercial entity.
Yes. May I start by saying that a municipality which provides a municipal service to its customer can do it in various ways. And the first port of call is to look at Section 76B, Roman 5 of the Systems Act, which provides that a municipality can provide a service, a municipal service, through an external mechanism. And in Section 81(2)(6) of that Systems Act again, it says it may also assign its powers and provides for an entity to provide service for its own account. Now, in other words, what that means is that when a municipality decides to outsource its service to an entity, it can do it in many other ways. In recent times, it can do it by way of what is called public-private participation, a PPP, and also it can do it as an external mechanism, but granting the concessionaire, in this case, an unfettered power to do business, as it were, and collect money and disperse it in the way that it feels, which is what happened in this case. Because CESA was appointed pursuant to the provisions of the Systems Act as an external mechanism to provide water to its services, but for CESA to make money out of it. So it is not just...
Sorry, Mr. Madonsela, is that the case that was put before the minister, that CESA was making excessive profits? And therefore the differential treatment was justified?
Yes, it was a point that was made that CESA does not makes money but does not plow it back to the system of.
But that's a different point. That's a different point.
We see as the same point, because the argument which Umngeni Water made to CESA as well as to the minister was that CESA is collecting money, is making business out of providing water to its customers, but that money is not plowed back to the service delivery.
But Mr. Madonsela, it was a long-term contract. Sorry, this is my last question to you. Yes. It was a long-term contract, 30 years. Obviously, yes. CESA had to plow, and I use your terminology, plow back profits or to its operational costs and to pay back the capex, the loans that it made to provide the infrastructure for this reticulation. So I don't understand the facts that were put before the minister, that taking all that into account, that then CSA was making excessive profits, which was not plowed back.
Justice Victor, I think this is also the problem with the SAA judgment. There's a misunderstanding about what was the concession agreement all about. The concession agreement regulated reticulation of water, which is something different from provision of bulk water services. So when you look at the concession agreement, you're looking at an agreement that regulates reticulation and not provision of bulk water services. So that makes a difference. But in relation to provision of bulk water services, the regulation agreement is a tripartite agreement. And it is a system by which the municipality is providing water to its customers through an external mechanism, but giving.
But Mr. Madonsa, sorry, this is really the last one I'll put to you. CSA was a bulk water purchaser, as the other municipalities were, and as the other part of Ilembe was. Yet, then how can it be rational to treat it differently if it was a bulk water purchaser?
It had to be treated differently because CSA, well, because firstly, in the face of drought, that was that struck the KZN and probably the whole country, Umgeni Water decided, well, we're going to have a housing policy in which each and every customer is going to, from each customer, we're going to be able to recover all the operational costs for provision of water. But because CSA was not a municipal entity, and it was sourcing water from one subsystem, which is not Pipeline and Honolulu and Avondale, it could not have a way in which it would assist it to offset its cost against the revenue it made on a per scheme basis. So that was the problem. That was the problem with CSA. So it had to be dealt with differently because of its geography first, and secondly, as we explained in the affidavit, because of the level of service that CSA was being granted by Umgeni in relation to potable water. You will recall in the affidavit, to make this point in our heads back, you will recall that in 2012 and 2013, CSA made demands, and they agreed with Umgeni that they will be provided water and be guaranteed certain amounts of water kept in their.
Mr. Madonsela, can I interrupt you?
Yes, just whichever.
I would like to take you back, and I think that would be, according to me, where the starting point should be. And to the extent that you say or you contend that the SCA erred, I just want to establish from you whether it erred in applying PAJA or it erred in applying the legality. And I just also want to understand from you what actually is your case on the error of the test that the SCA or the High Court may have applied. And further than that, do you ride on the coattails of the minister, or you are riding solo? And if you are, in the heads, the minister seems to be disavowing any PAJA, if I understood them correctly. So I just want to know the state of play, where you are and where is the minister, and to the extent that I may have been wrong, I seek your clarification.
Yes, Justice, the SCA formulated the question as being one of rationality. And that is how the case was really run in the High Court as well. That's the decision to differentiate CSA was irrational. And the premise of the SCA judgment was that the matter had to be dealt with on rationality ground, which then is the reason why we submit that when the court moves on to say the fact that CSA was a private entity is irrational, is a conflation of the issues that the SCA formulated in the first place. Because that inquiry on whether it is a relevant consideration or irrelevant consideration, is a self-standing basis for review at a project. It's dealt with under Section 62E of PAJA. Now, it's a conflation. The SCA add in that regard. If it considered the irrelevant, the private nature of Caesar as an irrelevant consideration, then it conflicted the test of rationality, because that's not a test for rationality. It's a test for PAJA.
Can I just read or draw your attention to paragraph? I think it's volume 10, the SCA judgment at page 1025, with paragraph 54 under the heading result. Can you locate it?
Yes, I've got it just the top.
And what is your understanding about this paragraph? What test is been advanced?
Well, in the result, in the paragraph that you have pointed out to me, the SCA dealt with the issue as one of rationality. That's a rationality test. That's a classical rationality test. But what I quibbled with was the passages before them that founded that conclusion, where I think it is in paragraph 50. I may not be correct about. Let me just check the right paragraph.
I tell you what paragraph there is.
Sorry.
Check the paragraph 21 where it says it's dealing with the law.
If I may just
let me draw your attention again to paragraph 21, and while putting your finger on paragraph 54, and compare the two.
just I'm back with it.
The test in paragraph 24. In paragraph 21, sorry, and paragraph 54. What do you make of these two paragraphs?
Paragraph 21.
And paragraph 54 that we've just referred or dealt with.
Yes, paragraph 21 asserts a PAJA review, but the result is a legality review.
So is this what you are contending that about a conflation of the two tests?
Yes, that's exactly what the point I'm making, just much over.
And in your submission, what is the proper test that ought to have been applied?
It goes back to what we said initially. We said you've got the discipline of the court in the judgments which have proceeded from this court is to try and characterize the power that is being exercised first, whether it is executive or administrative action. And once you proceed from that point, then you move from that premise and say, well, is it going to be a review under PAJA or under legality? So the point we're making is that in the judgment of Justice Kampempe, none of the judgments, I think it's Motau, and even the judgment of in PG Group. If you look at the minister's power, let's first talk about the minister's power. When the minister's power approves tariffs recommended to it by Umgate, it is quintessentially an executive power that should only, in our submission, be subjected to a lower threshold of scrutiny under legality. It should be a rationality review. It should not be a party review. That's our standpoint. And secondly, even if it was to be for some reason regarded as a party review, it is one of those cases where the court should exercise a due difference because the nature of the power being exercised by Umgeni and the minister in jiggling around with all sorts of considerations is one that surely the court in the Batterstar judgment of Justice Oregon have said that it's a case really that requires the courts to give due deference to the administrators who are making that decision. So we
Mr. Madonsela, for us to intervene, I'm using the words guardedly. Firstly, we have to look at the judgment of the SCA and find whether there are faults in it or not, what you'd call errors. And if the test that has been applied by the SCA, or it has employed double tests, right? You would say, had the SCA applied a proper test, the outcome would have been different.
Yes.
And you would say now, because it applied a mixed test, it has produced an outcome that gives us mixed feelings, hence this appeal.
Yes. Justice Matopa, I could not have made it any better point than you have done. Thank you for that, Justice. Justice, that's in essence our submission is that firstly the SCA got the test wrong, and secondly, and it contradicted the two standards of review. If it had applied the correct standard of review, which is a legality or rationality review, a lower threshold review, the outcome would have been different. And the
Mr. Madonsela?
Yes,
Mr. Madonsela, on that very question, the SCA in the judgment in the paragraph that Justice Matopo referred you to suggests that the rationality standard in the context of PAJA is lower than the standard to be applied in a review based on the principle of legality. That's what paragraph 21 of the SCA judgment seems to suggest.
Yes.
But having regard to this court's judgment in Similani,
yes,
does it matter? And I refer you in particular to paragraph 44 of the judgment in Similani, where this court said, in other words, the question whether the means adopted are rationally related to the ends in executive decision-making cases somehow involves a lower threshold than in relation to precisely the same decision involving the same process in the administrative context. This is wrong. Rationality does not conceive of different thresholds. It cannot be suggested that a decision would be irrational in an administrative law setting might mutate into a rational decision if the decision being evaluated was an executive one.
Justice Tarani, you are correct when you point that out, because the rationality standard is the same. I think Justice Kampembe in PG Group case, in National versus PG Group, has made this point very poignantly and said that, you know, you can't have different standards for rationality under PAJA and legality. It's the same standard. Of course, the debate becomes very different when you talk about procedural irrationality as opposed to substantive rationality. If we're talking about substantive rationality, which this case was all about from the very word-go, the standard ought to have been the same. But that really points out that the SCA got that test even wrong, because we can't have different standards for rationality under different platforms. Whether you approach things from the milieu of PAJA or the plateau of legality. The result must be the same in our submission. But that's the problem with the SCA judgment in testing, in really reviewing the tariff decision that is in this case. So we submit, that in any event, the SCA got the test wrong, but it conflated the test again and then misapplied it for all the reasons.
I'm sorry to interrupt. I am a bit confused. Are we here dealing with rationality standard as we understand it, and as it appears in paragraph 54 of the SCA judgment? You know, the test of determining a rational link between the means and the end. Or are we here dealing with something completely different based on the proposition that the differentiation of Caesar on the basis that it was a commercial entity cannot be rational, which is something completely different, which suggests to me that on the second leg, you go into the evaluation of the reasons for the differentiation, which has nothing to do with rationality. What you're determining is whether those reasons are good enough to justify the decision, and that is not rationality as we understand it. So I need to know, what is this case all about? Because the SCA seems to have conflated the two and came to a conclusion.
This case was primarily about whether it was open to Mungeni to differentiate. And that is a standalone point. And once you have resolved that issue, well, it had the power, and its policy allowed it to differentiate between its customers. And that's the first point. The second point is whether the reasons given for it are good enough. The rationality of it, well, rationality has got many components. Insofar as it relates to whether Mungeni and its policy accorded it the power to differentiate, we understand this to be no issue. There was no issue about that in this case, because as the SCA said in paragraph 20 and paragraph 54 of the judgment, it assumed that the power to differentiate was always there. So that's the premise of the case. So the question was whether the reasons given for doing so were actually rational or justified that conclusion. And again, the SCA then does not get that right in the first place, because then it does not pay attention to the right documents which gave the justification for it. But at the end of the day, it says that consideration was a rationality inquiry. It was not. It was the rationality of it really dependent on whether it does have the power to do so. Because rationality involves whether you are acting within the four corners of the law.
And how was the ground of rationality pleaded? Can you remind us?
In the answering affidavit, in the founding affidavit rather, you will have seen that at page wasn't very suspicious. That's a temper. Can bear with me, Justice Jefter.
Page 36 of volume 1, maybe.
It's paragraph 76. Yes, you're not just Victor or Justice Teran, but it also started much earlier, because at paragraph in the earlier paragraph. Paragraph?
71 at page 34.
71 at page 34. It was pleaded. This is just, I think, what they did in the founding affidavit. If you go to page 30, paragraph 60, they said that the differentiation was a discrimination that was not justified under PAJA.
Mr. Madansela, perhaps if I may assist you, Mr. Madansela.
Yes, Justice correct.
Paragraph 7 on page 10 of volume 1 sets out the nature and the basis of the application brought by CSIR.
Yes, Justice Karonga. That's the premise on which they, of course, they at paragraph 7, you'd have seen that they sort of approached the matter with belt and braces. They said it's PAJA, but if it's not PAJA, it's legality. But then as the SCA rightly appreciated, the issue ultimately was never really about whether there was no power to differentiate, but the question was really, as it formulated, was whether that differentiation was rational for the reasons given to it.
Mr. Madansela, just so that we don't, you don't have to come back to what you should have addressed. My brother Jafta asked, how was rationality pleaded? Have you answered him?
It was, may I just attempt to do such a justice?
Because you referred to a number of pages and paragraphs, and even when my sister Teron was referring you to a particular page, I didn't get a sense that you were accepting it as a response to my brother Jafta's question.
It was pleaded as a PAJA review in paragraph 7, as Justice Dillon has pointed out. And it was also said that if it is not PAJA, therefore it also would be a ground of review under legality.
You see, my difficulty, Mr. Madansela, is why are we straddling between rationality as we know it and justification for a decision as in the context of an arbitrary decision? Because if we understand what the case is, then we will be able to say the SCA is wrong, because in paragraph 54 that you debated with Justice Matopo, the SCA suggests that we're dealing with rationality as we know it. That is, the power was not exercised for the purpose for which it was granted. There is no link between the means and the end. Now, the difficulty is with that approach, the SCA does not tell us, firstly, what was the purpose for the power given to Umgeni Water Board to set tariffs? Because you can determine the lack of rational connection between the means and the end if you don't know what the end is. So you have to start by saying, this is the purpose. The power was exercised to achieve a different purpose, and therefore there's no rational link between the means adopted in exercising the power and the purpose or the end for which the power has been granted. So that is the problem that we have with the SCA judgment. If we approach the matter on the basis that it is a simple rationality test or review as we understand it, there are problems. But it may be different if the case is that whether the reason given for differentiation is good enough to justify differentiation In other words, the differentiation is arbitrary. That's a different approach altogether.
Yes,
Am I making sense?
You're making sense, Justice. You are correct, because if you say the justification is a wrong one, you are in the realm of arbitrariness, whether the decision was taken capriciously, which is a proper parja inquiry. But Chief Justice and Justice Chapter, I struggle to point out what exactly was the premise of the SCA, because it was a wrong premise. I'm not here to defend the judgment of the SCA. In fact, I'm punching holes in the mouth. I have difficulties with this in the same way that you do. That is actually the essence of this case, that the SCA got the test wrong and conflated PAJA rationality standard and the other PAJA, the legality rationality standard and the PAJA review standard, either under arbitrariness or under the consideration of relevant considerations. So we say for those reasons, the SCA judgment is susceptible to set aside. And then the matter should be approached purely on PAJA. And to answer your question, Justice Jaffa, the case was really about Section 30, the imposition of tariffs by CSIR, exercising its power under Section 34 of the Act. And the power was given for CSIR in order to have flexibility in imposing tariffs amongst its customers, and whilst doing so, strive to strike a balance between its financial viability and being fair to all of its customers. That was the purpose for which the power was given under the Act. The Umgeni Water then, the means through which it did so, it passed a policy which then gave it the power to differentiate between its customers by accounting for them separately. And in relation to CSIR, as a justification, why CSIR had to be marketed with a high tariff was because CSIR was differently placed compared to other customers. That is, at its basic, the case was all about. The power was exercised by Umgeni in order to achieve the purpose given in the Act, Section 34, to strive to strike a balance between various considerations of financial availability of Umgeni. And there was nothing in our submission that was susceptible, that made that decision susceptible to review. So that's what the case was all about.
Okay, on that approach then, we know that it's not rationality as we know it. On that approach then, our jurisprudence is to the effect that we still have to draw a line between a review and an appeal. When a court is assessing whether or not a decision impugned is arbitrary, how far does it have to go in the evaluation? Normally, reasons are evaluated in an appeal situation. But now we know that the complaint is that the decision itself is arbitrary. And for us to determine that, we have to look at the reasoning.
Please.
How far are we permitted to go as a court in evaluating the reasons given? Are we free to evaluate those reasons as if we are in an appeal situation?
To do so, Justice Jefter will blur the distinction between a review and an appeal, because the appeal is about whether the decision was right or wrong. But the review is about the regularity of the decision, whether the given, having regard to the reasons given for it, was it one that was within the range of possibilities that the Umgeni, that were open to Umgeni to take under the circumstances. So it's a very narrow, under review, the standard of review is a very narrow one to check whether that the reasons given for it are within the permissible range of a number of reasons that Umgeni could have taken.
I hear you, but I'm not quite sure the extent to which we should go. I'm grappling with that in my mind. I thought that you could help me.
Well, you can go as far as to examine what was placed before the Umgeni, what was placed before Caesar, as well as the minister, insofar as the rationale for differentiation in this case, or for imposing a high tariff in relation to Caesar. And that rationale you will find at page 76 and 75, so page 75 and 76 of the papers, where all of the reasons were given as to why it was important that Caesar should be dealt with differently. And once you are satisfied that those reasons are within the range of permissible reasons, then you don't have to go far enough and then second guess the decision of the municipality of Umgeni Water in this particular instance.
Thank you.
Chief Justice, those are my submissions.
Mr.
You unmute yourself, my brother.
Thank you. Can you hear me now, Mr. Madonsela?
I can hear you, Justice Mazanga.
Thank you, thank you. Just before Justice Mshantla came in and asked you a question, you were referring to what I think is the more than 200-page document, and you said the reasons appear fully there as to what the motivation behind the increase was. Can you please clarify to me whether the reasons that you are referring to or alluding to were specifically referred to in the affidavits themselves, that is in Umgeni's affidavits, because as you know, there is the principle, I forget the AD or SCA judgment, but it starts with a T, that's all I remember. But a judgment that says, but it makes a, I see my brother Justice Chapter is laughing. But it makes a point that was made in an earlier judgment of the Cape Provincial Division in the matter of Port Noloth Municipality versus Xalisa, which is that you cannot in argument refer liberally to what appears in annexures without specifically having drawn your adversary's attention in your affidavits to the particular parts of the exhibits that you want to rely on. So that is why I'm asking whether in the 200-page document specific reference was made in the affidavit, that is the Umgeni's affidavits, as to what you would rely on.
Justice Madlanga, are you talking about the concession agreement?
Justice Madlanga, you're on mute.
This is in the context of you criticizing the SCA for saying that Umgeni was relying on grounds that, as it were, are new, in the sense that they were not earlier relied on. But you say that is wrong because these reasons, grounds, or bases are actually contained in a document that is more than 200 pages long, which was furnished to Caesar as part of the Rule 53 record, if I understand your argument correctly. So my point is, fine, those may be there, that is in that 200-page document, but where the reasons that you are referring to or the grounds or bases that you are referring to pertinently relied on in Umgeni's affidavits.
Mr. Madonsela, please unmute yourself.
Justice Madlanga, at page in the written submissions at page 39, we deal with what we call the seventh pillar of the several errors which we point out in the SCA judgment, and we refer there in the answering affidavit of Umgeni, where the issue relating, we identify the paragraphs where the issue was dealt with. Remember the issue, Justice Madanga, was whether did we ever mention that there were schemes which could be utilized in relation to the other municipalities which could not be dealt with by, which cannot be given to Caesar Water. And then we refer to the record. And might I probably start by saying, and just probably go to the annual review itself, because there the issue was raised during the consultation process initially, before I even go to the letter at page 75 and 76. The annual review at page volume 6,
You actually don't need to get into any detail, Mr. Matonsela. What you could just simply do is to say, with regard to this, look at paragraph that of the answering affidavit. With regard to this paragraph, you don't even need to argue. Just so one can actually see that what you are alluding to was indeed pertinently referred to in the affidavits. You don't even need to speak to it. Just that cross-referencing.
It's paragraph,
with particular reference to the affidavits.
The affidavit, you will find this at paragraph 137 at page 137, paragraph 27. And then you'll also and then paragraph 75. It's page 75. It's a letter written to Caesar page 75. It's a letter written to Caesar explaining that we can't utilize, there is no, to read it, it is rather unfortunate that with Caesar Water, there are no other cheaper systems against which the losses incurred while supplying them from Hazelmere system can be netted off against. So it's there in the letter written to Caesar to explain why there was a high increase on them. And also it's paragraph 24 at page 135. It's page 135, paragraph 24 of the answering affidavit. And paragraph 25 as well over the page, why it was necessary for Caesar to be marketed with a higher tariff. So it's all there in those pages of the answering affidavit.
Here's something else that I want you to please clarify for me. A point is made about a ceiling on the tariffs chargeable by Caesar, which is quote unquote initially set by Ilembe. And then you argue something like you draw a distinction between reticulation and bulk water supply. I get confused altogether because I thought in that context, the focus is on what Caesar is able to charge the end users. And it is with regard to what Caesar charges the end users that the point is made that there is a ceiling with regard to that. It's not as if CSA can charge anything it likes. So I don't quite get what the point you are making with regard to bulk supply as opposed to reticulation. I get confused altogether.
The SCA said the imposition of CSA is an immaterial or irrelevant consideration because CSA does not have a free hand to increase tariffs based on the approved tariffs by the minister. So we're making the point that no, actually, that's not correct. Because when you're talking about the tariffs that CSA is entitled to impose to its customers, ultimately, they do in fact have a free hand because that the tariff that we are talking about is not a reticulation tariff which is regulated by the concession agreement. The concession agreement, under the concession agreement, CSA pays to Ilembe an annual fee based on a very complicated formula, which is annexed in Annexure E1 of the concession agreement. But under the bulk services agreement, you would have seen we refer to specific clauses of the tripartite agreement, in which CSA was given the power to charge a tariff and deal with it in the manner that it deems fit. So to the extent that CSA is entitled to raise a tariff, and then it does have a free hand on what tariff it will charge the customers ultimately. Although—
Sorry, Mr. Madonsela, that free hand, must it still not be rational? It has a free hand, it's got those powers, but must the decision still not be rational, bearing in mind that CSA was servicing indigent consumers as well?
I think, Victor, I think we're talking, I'm talking about the fee that, the tariff that CSA will be entitled to charge its customers. And the fee that CSA will be entitled to pay to Umgen Water Board. Under the bulk services agreement, CSA is charged a particular tariff in this particular, for all these years, it was 8.3, it was being increased now to 38.3. But in relation to its passing that on to its customers, the extent to which you would have seen at page 699, for instance, clause 5 of the concession agreement, it deals with how CSA will then be able to charge customers directly for all the monies it collected as it deems fit. So it will have to then determine for itself how much it can raise as a tariff to its customers pursuant to a tariff fee imposed on it by CSA. Justice Madlanga, it may very well be regulated by Ilembe at some level, but the interface between CSA and Ilembe is something that Umgeni has got no control over because it's not a party to the concession agreement. So it has to do its part for its own bulk services. And what it does with Ilembe is something that Umgeni Water can do nothing about. So we say, from that perspective, we have no control of what they charge ultimately. So they do have a free hand on how they negotiate with Ilembe. I think the story of this case—
But surely though, how much you increase by, it should have a bearing on what CSA is able to charge based on the ceiling that Ilembe has imposed. If there be such a ceiling, and you seem to be conceding that there may well be. So it cannot be that Umgeni can simply shut its mind to that as a factor. If we increase by 50%, but will Umgeni still be able to operate under those circumstances? It cannot be an irrelevant consideration.
cannot be an irrelevant cost adjustment, but the problem with this case is that there was no engagement with the impact, and that's the point we make in our heads of argument. There was no engagement in the affidavit with what impact an increase that will be imposed by Umgeni would be to CSA and its customers. Because if that engagement had been involved in the papers to demonstrate that there was going to be something wrong, extraordinary wrong, it's not the case that is before this court, it's not the case that was pleaded, and therefore could not have been a consideration that should have led the court to review the tariff.
I'm raising it purely in the context of your query, you know, about and drawing the distinction between reticulation and bulk and so on, something on which I think you are talking at cross purposes with regard to the point that the SCA was making, whether rightly or wrongly. That is the only reason why I'm raising the issue. I just felt that your response is at cross purposes with the point that the SCA was making.
But I can just in response to it, I can say it may very well be that ULEMBE does regulate the tariffs ultimately. But the problem with this case is that this case was not fought on those frontiers. There was no engagement on what impact will there be, if any, to the customers because of the hike imposed by Umgeni on CSA.
Mr. Madansela, the impact of the increase, is that not something that Umgeni Water should have considered before it made its decision? Is that not a factor it should have taken into account when it was making its decision?
Justice Terod, you would have seen there was at page 594 of the record, all the way there's a PowerPoint presentation made to CSA about the increase. And it was CSA. It is not as though CSA was not forewarned, and CSA had to, at that consultation level, had to engage with Umgeni about what the impact would be. Nothing was forthcoming, except other arguments which are irrelevant. But the consultation process was exactly for that purpose, to say here is what our thinking is, and this is the increase that we want to impose on you by of tariff. The consultation process was exactly for that, to assess what impact that would have on the customer. But there was nothing by way of either in correspondence that can be shown in these papers or engagement with it in the affidavit that says that the impact of what you told us we're going to increase the tariff by will have an adverse effect on us. So it is something that Umgeni would have considered, and that's exactly the reason why they had to consult CSA on it and determine whether.
Are you saying that even as we sit here today, no evidence has been presented to Umgeni about the impact of its tariff increases?
Yes.
Its impact on CSA as a company and its impact on the end users?
Yes. There's nothing.
How can Umgeni justify that decision?
It justifies, for instance, it is at page 617. It says, we want to eliminate the extent of cost submission by one customer to the other. And we want to have a full cost recovery per customer. And we can't, there's no way in which we can deal with CSA in any other way that is less, that will result as imposing a lesser tariff. So that was the rationale. That was the justification for it. We have adopted a policy that we are going to recover from each customer the entire operational cost, and we're not going to allow a process by which one customer is going to cross-subsidize another one. And in the case of CSA,
I understand what you're saying. This policy in respect of CSA was adopted without Umgeni Water knowing what the impact of that policy would be. and that Umgeni Water was waiting for Caesar to advise it of the impact of that policy.
Yes. And in this case, to add on that, Justice Darren, to add on this case does not even, Caesar does not even attempt to mount a challenge against the adoption of that policy.
But shouldn't Umgeni Water be able to justify the policy, the introduction of the policy?
We would have justified it if it was properly challenged.
So they would only justify it if it's challenged.
There is a justification for it. It's just that it does not arise in this case because there was no frontal attack on the policy.
Yes, Mr. Madonsela, with the leave of the Chief Justice, if I could move on to another question. In terms of the concession agreement between Ilembe and Caesar supplies a particular area with water. Ilembe supplies the areas not covered by that agreement with water. Is that right?
That's correct.
Now, for the area that Caesar applies, the tariff is different. For the area that Ilembe applies, the tariff is different. If Ilembe had to take over supplying water to the parts of the area that Caesar was previously supplying, then they would be supplying at a lower rate. Is that right?
It's possibly, yes. Possibly, I say possibly advisedly because I've got an answer that I can give in relation to that.
Please give the answer, Mr. Madonsela.
Yes, the only difference that would be because this is the debate we had in the SCA. What happens if you remove Caesar? What will happen if you remove Caesar in the chain of provision of service is two things. One, you will be able, firstly, Caesar or the people in the concession area will not benefit from a higher level of service that is provided to Caesar currently. And that is one of the bases on which Umgeni is entitled to differentiate its customers in its policy. And I've explained with reference to the addenda to the bulk service agreement of 2013 and 2014, 2012 and 2013, that Caesar does enjoy a greater level of service because it has got reserves for it during the peak season, which are not going to ride down because they've been guaranteed between them. That is an important consideration. The second consideration, which is foreshadowed in the affidavit, is that what will happen is that Caesar or the customers within the concession area will not enjoy the uninterrupted service, which is not the case outside of the concession area. So that's the problem. Caesar once insisted in 2012 and 2013 that it should have a posh service, but they don't want to pay for it. So to those to whom more is given, more is required.
You're quoting from the Bible now, Mr. Madonsela.
So that will be the difference.
So in the area covered by the concession agreement, if Caesar had to pull out of that area and Ilembe take over supplying water, the rate that the end consumers would pay would be less than if they were to receive, those people within the concession area was to receive water from Caesar. Is that right?
Well, Justice, it will really depend. I mean, no one knows the future, but it will have to be negotiated between the Umgeni and Ilembe in relation to that supply of the area. The area is that Palito, Zimbali area, which is during peak season, is basically a high demand for water. So there's infrastructure that is put. At page 76 of the papers, where the letter to Caesar, we explained this to Caesar and said, look, the Zimbali area has now required us to put up reservoirs. and put up all sorts of infrastructure.
Sorry to interrupt you. Perhaps I didn't phrase my question accurately. Let me try to rephrase it.
Then just
If Ilembe was to supply consumers within the concession area, they would be able to charge their end consumers a lower rate than what CESA was. On the basis that Amgeni Water would not be able to say to Ilembe, for the price of the water that you supply within the concession area, this is the rate we're going to charge you as Ilembe. Amgeni Water could not say to Ilembe, for the price of the water that you supply outside of the concession area, we will supply you at a lower rate. The only basis upon which Amgeni Water could make that differentiation is because, as I understand it, CESA is a private company. It would have to charge Ilembe, it would have to fix the rate for Ilembe at the same price it fixes for other municipalities, whether Ilembe was distributing water within the concession area or outside of the concession area. So if tomorrow Ilembe started distributing water within the concession area, their rate from Amgeni Water would be the same as the rate they receive from Amgeni Water for the area they supply outside of the concession area.
That's not correct, Justice. That's not entirely correct. What would happen if CESA was to be removed from the line, service line? Is that firstly, the quality or the level of service of the consumers in the concession area will be different.
Can we just stick to the rate, please, Mr. Madonsela? The price fixing rate that Amgeni would impose upon Ilembe if it was to supply water within the concession rate and concession area and outside of the concession area.
I don't know what the rate will be. It will probably, in my speculation, it will probably be the same. But the only difference the only reason why it will be the same is because the concession area would become part of a larger district area of the municipality, where the Umgeni, for instance, can utilize certain other schemes which are within the Ilembe district in order to offset its costs at the operational cost. So it will be part of the huge mix from which Umgeni can be able to jiggle around, because the permutation will now be open to the entire district area of Ilembe, not be confined to the area of the concession where CESA operates. So it will make a difference in the number. Firstly, the permutations of offsetting the costs will be spread across the entire district of Ilembe. Secondly, the level of service will be different, because then they will not be entitled to the guarantees that they now have for the reserves. Thirdly, they will also suffer the outages, water outages in times of trouble, like everybody else is suffering. Not what is currently the position now, where there are there are guarantees about outages or water cuts.
Mr. Madonsela, Mr. Madonsela, can I just want to find out if, in terms of your policy and your norms and standard, you are, as Umgeni, entitled to apply those differentiation. And if so, where in the policy or in the norms of standard does it authorizes you to do so?
To do what?
To differentiate.
Differentiate. Can I ask you to go to page 197? It's closed. It's page 198. It's the third paragraph.
Just bear with me. 19.
198. It's volume 2. It says, if I can quote, a water board may set a single tariff for its whole supply area, or it may set a separate tariff for each bulk system or group of systems. Tariffs may be differentiated on the basis of type and level of service provided, geographic area, customer profile, and may be smoothed over time.
Thank you.
But Mr. Madonsela, when it does differentiate, doesn't that differentiation have to be rational?
Maybe before you come in, my sister, let me just try and clarify something with my colleagues. Colleagues, are we going to take a break now after Mr. Madonsela is done? Or should we allow Ms. Moroka to first indicate whether she's going to go all the way or be as brief as she suggested she was going to be, obviously depending on colleagues' desire to seek clarification from her. Are we going to take a break after Mr. Madonsela, or should we go all the way? If colleagues could just indicate. I know we didn't discuss it. Can I get an indication? Justice Jafta, you are smiling. Maybe you should go first.
I would love to have a break, CJ. Just a
After
short
Mr. Madonsela, or right away?
After Mr. Madonsela has finished.
Thank you. Colleagues, can we have a break only after Mr. Madonsela has finished? Well, your silence, I will assume you mean yes. Is it going to be 5 or 15 minutes?
5 minutes will be okay for me, CJ.
Okay, let me just find out from colleagues who may just wish to have a cup of coffee. Colleagues, will 5 minutes do, or should we make it 15?
Let's make it 15, CJ.
Okay.
All right. Well, it takes one just to get a sense that I need to accommodate. All right, it will be 15 then. Yes, my colleague, Justice Victor, please go ahead.
Thank you, Chief Justice. Mr. Madonsela, whilst Mgeni Water has wide powers for differentiation, doesn't that differentiation still have to be rational, taking into account a wide range of factors, including the end consumer? And isn't that information necessary to be placed before the minister?
It has to be rational, Justice Victor, and that is precisely the reason why there was consultation, wide consultation about it, so that those who are affected by it, so that the rationality of the decision can be debated with them. The consultation went through, and it was discussed. The issue was discussed on the basis that there will be a high increase, and in this case, in this court, and in these pleadings or in previous correspondence, there's never been an issue about whether it is irrational to do so, except for the arguments which we have dealt with today in relation to this case. So the standard, of course, it has to be rational. And rationality really is the inquiry about whether what you are doing is you have the power to do it, and you are achieving the ends which are envisaged in the section that empowers you to do so. Is that the Albert link between purpose and the means?
Mr. Madonsela, what is the legitimate government purpose served by the differentiation? My understanding of authorities is that if the differentiation does not serve any legitimate government purpose, it is irrational in the context of being arbitrary. Now, this one, because we know that the Constitution does not prohibit differentiation, But that differentiation in the present context must not be arbitrary. So as I understand the debate now, what is the legitimate government purpose served by this particular differentiation of CSER from other similarly situated service providers?
The legitimate governmental purpose that is served is to ensure that Umgeni is financially stable. And the Act Section 34, as well as Clause 21 at page 197, articulates this governmental purpose. What I think was intended was to allow Umgeni to provide water to its customers, but in the process not to cripple it financially. So it was really the question of really striking that balance between ensuring that Umgeni is not crippled, especially in times of drought, which we found ourselves in 2014. That Umgeni is able to provide its customers with the water, at the same time striving to be financially, striking the balance between, on the one hand, striving to be financially viable, and on the other hand, being fair to its customers.
But Mr. Madonsela, the contribution.
Sure, I understand that. It's my understanding that the total cost for providing this service would be well over R1 billion, and all that the increment was going to help you raise is some 10 million rands. How then does the additional 10 million rand contribute meaningfully towards cost implications that run into well over R1 billion?
What the policy provided was a formula in which all the basket of considerations would be factored in to work out what is an appropriate tariff to cover the operational costs, as well as to fund the project in the long run. Remember, Justice, the idea is not to have the customers pay for it now, all of it now. And that's why the policy talks about smoothing in tariffs over a period of time in order to cover those costs in the long run. It is a goal, it's not the end. The goal, but you have to start somewhere in order to find the project. There may be billions, but then what happens, I can take you through it, but the formula is quite complicated. It's in the annual review. What the Umgeni did was to say, to start the process of being able to recover our costs, let's do what is called tariff smoothing, by imposing tariffs in a way that makes sure that we recover our cost of operations, whilst at the same time allowing people to access potable water through our services. So that was the formula that was. I can take you through it just if it
No, Don. No. I just wanted one short answer that addresses this need to achieve financial stability that you alluded to.
Yes, just.
So that's your answer. You're saying in the long run that legitimate governmental purpose was going to be served by the tariff increase.
Tariff increase when you smooth it in over a period of time. Of course, the only final point that I need to deal with is probably the questions of cost, and we submit that the leave to appeal should be granted, and that the appeal should succeed, either under the rubric of the minister, or if you find your way into dealing with the Umgeni's water appeal, which is not strictly necessary, and our submission to uphold the appeal and set aside the judgment of the SCA, and and order that the application ought to have been dismissed with cause. And the cause should be the cause of two counsel in all the courts.
Yes. Well, maybe part of what you and Ms. Moroka must reflect on and communicate to us after the adjournment is who of you is going to reply. Is it going to be you? Is going to be Ms. Moroka, or do you both want to reply? Because I'm not too sure how you seek to manage this process. The court will adjourn for about 15 minutes.
Court will adjourn until 11:55. Please note that during the adjournment, you're welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:55. Should you exit, you may use the same link to rejoin the hearing.
Wena, my sister, uphungi.
Chris, we are live. Careful.
Are we?
Are we
all
alive?
alive? Are we all alive? Because you've been talking. I were not alive.
Thank you.
We were not.
Thank you.
Justice Teron, are we all in?
Yes, Chief Justice.
And counsel?
We are here, Chief Justice.
Thank you.
All
Yes,
counsel-
Ms. Moro.
Respondent
Thank you.
are also there now. Thank you.
Thank you. Thank you. Yes, Ms. Moroka.
If I may, Chief Justice, start off with the housekeeping issue that you raised and inform the court that Mr. Madronsela is going to do the reply.
Okay. Very well. Do you have submissions to make?
I do. As I had earlier indicated, I don't need a lot of time. And I've spoken to my learned friend, Mr. Kemp. What I do wish to alert the court, I would imagine, is two things. The first thing is that I take no issue with the submissions by Mr. Madonsela. And I think on the basis of what he has submitted, we do support him. We have a different role and a different power, which I need to address this court. We have come to court to apply for leave on the basis, if with reference to page 973 of the appeal record, we set out in those paragraphs why it is that we think that the court has jurisdiction. And then I also would wish to refer you to paragraph 40 of our heads at page 13, where we talk to the fact that the minister must exercise power and perform the functions that are conferred upon her by legislation, by the law, by the constitution, and the fact that she cannot go beyond those powers, because then the issue of legality is engaged, whether she acted beyond her powers. If you have regard to what the SCA said, and more specifically at paragraph 20.
Well, maybe before you go ahead, Ms. Moroka, it wasn't clear to me whether you're going to need time without interruption or whether you're happy to be interrupted from the beginning.
I can be interrupted from the beginning because I'm going to be very short.
Thank you.
And if I refer the court to page 1007, where the court intimated that Ngeni was entitled to impose the water tariffs in the manner it did and differentiate because it had that power. And furthermore, the court referred to the norms and tariffs dated the 13th of November, 2015. We need to say to the court, we have premised our opposition to the application by the then applicant in the Quota Core and the SCA on the submission that we had the power in terms of Section 10 to be the policymaker and the head of the department as a political head of the department. We therefore also had, in terms of the Act, the Water Services Act, the power to promulgate norms and standards in relation to how tariffs were going to be set. We mistakenly believed that the 2015 norms and standards were the standards that were applicable. We based our understanding of the power that we had on those norms and standards. As it turns out, we were wrong. as it turns out, the SCA relied on those norms and standards that we had indicated were applicable. As it turns out, the norms and standards that we intended to promulgate were not promulgated. And the 2011 norms and standards are the ones that are applicable. And therefore, having said that, it talks to the position that we find ourselves in, that we may have had the powers to promulgate the norms and standards, but actually we didn't go so far as to do that. And therefore, in terms of those norms and standards that set out in very detailed form how differentiation is to occur in setting tariffs, we did not promulgate those regulations. We refer in our case to Regulation 7, for instance, and Regulation 6. That was not applicable on the 15th of May 2015, when we accepted Umgeni's application for tariff change. And therefore, that puts us in a situation where we have to say to the court, a mistake happened, an error occurred, there was a reliance on that error. But having said that, from a factual basis, we accept what Umgeni has submitted to the court. And that really is what I needed to say, Chief Justice.
Colleagues, any question before I call on Mr. Gam?
Ms. Moroka, can you clarify one thing for me? Did the minister have to approve the tariff set by Umgeni? And if so, what was the source of that authority?
We believe that the minister had to approve to be able to table it in Parliament, because at the beginning of if you look at the genesis of this case, there was a point where we were of the view that Ilembe was a mandatory, CESA was a mandatory. And the notion that CESA was not a municipality would have been the position. We are of the view that CESA has stepped into the shoes of Ilembe, a la all pay. And therefore, we are obliged by the Act to approve tariffs that Umgeni is entitled to set the tariffs. We are obliged to then approve them and then table it with the concurrence of the Minister of Finance to Parliament.
Yes, I'm interested in the provision in the Act which empowers the minister to approve.
If I can go to section 19, I think. I'm looking at the Act in a very small print. I think you don't find it the Services Act. There's an echo. Sorry. It's the Municipal Finance Management Act, I think, if I'm not mistaken. And it would be section 42. I'm not very sure. Can I come back to you on that one? But it would not be in the Water Services Act. It would be in the Municipal Finance Management Act.
Yes, I have looked at section 42 of that act, which facilitates the tabling of the tariff in Parliament. But I did not notice any power given to the minister to approve the tariff in that provision.
Well, I would imagine, Justice, after that, it would be inherent. You cannot table that which you have not been given the power to approve, on what basis would you then be tabling it to Parliament?
There are many issues that are tabled in Parliament through ministers, where ministers did not have to take a decision. I think the tabling in Parliament is a facilitation of placing the issue before Parliament. It's not an issue of approval, as I see it, but I may be wrong, but my reading of Section 42 of the Municipal Finance Management Act is that it does not empower the minister.
Well, Justice Jafta, I suppose we look at it differently, and I can't take it any further as to say the implication is there that we had the power of approval.
So it's not expressed, it's implied.
It's not
Is that the submission?
Yes, it is. Having regard to the powers that are envisaged in the Water Services Act, that you can't do that, you can't, for instance, set tariffs that are outside the norms and tariffs. Who then is the arbiter of all of that, if not the minister?
You see, in respect of electricity, the tariff would have been approved by NESA, isn't it?
Yes.
Not minister. Yet it has to be tabled in Parliament.
But it's expressly provided that way. The structure of the Water Services Act and the structure of tariff setting is different. If you have regard to how is it that we give you the framework to set the tariffs, how is it that you can't go beyond those tariffs and do something other than what is said in the norms and the norms and standards? Surely there must be a final arbiter of whether you did that or you did not do that.
No, I was mentioning electricity in the context of Section 42. It's one and the same section that facilitates the placing of tariffs before Parliament. So I was saying Section 42 itself realizes or acknowledges that in respect of some services, it's not the minister, it's an agency established that approves the tariff. But still, the minister has to place the tariff before Parliament. I was addressing the point that you were making, that how can you place before Parliament something that you have not approved?
I take your point, Justice. The only point that I was saying is that I believe that when you look at legislation, you must look at all the powers that you have in a continuum. You can't just read 42 apart from the Water Services Act and what it is that I'm obliged to do as a minister under the Water Services Act.
Can I ask you this? Once there is a mistake about the norms and standards, could the decision by the minister have then occurred at all, or was it then alternatively, could it be rational, his decision?
I believe, Justice Victor, that having regard to what was tabled before the minister, it might be in terms of strict law that the minister didn't have regard to the norms and standards because they were not there, but the 2001, but what was tabled before her to consider as the rationale by Umgeni, she was able to come to the right decision, notwithstanding that she misconstrued which norms and standards she was relying on.
Ms. Moroka, as I understand the applicant's, the minister's case, and this appears from your heads of argument as well, and I would like to refer you to paragraph 63, 78, and 79 of your heads of argument.
63,
78, and 79. The minister relies on Regulation 7.4. the minister says he was empowered by Regulation 7.4 to set different tariffs and to differentiate between different water users. If the minister's case now in respect of Regulation 7.4 falls away, on what provisions or what regulations and what part of the regulations of 2001 does the minister now rely on? Does the minister say gives her the authority to differentiate between the tariffs and different water users?
Well, Justice Teron, I have conceded and accepted that the minister, because of the lack of regulatory power, that she didn't have those powers. She would have powers not as set out in 78 and 79, but it would be powers that are strictly confined to the 2001 powers that tangentially refer to differentiation, that do not refer to differentiation in the manner that 78 and 79 here does.
Can you assist us then? What powers does the minister have under the 2001 regulations, and which regulations in particular does the minister rely on for her power to differentiate the tariffs between different water users?
If you go to page 336 of the record, 337, my difficulty is that speaking for myself and the minister, I cannot pinpoint that power. Because if you look at, I don't know whether you're there, at page 337, clause 4, what that says is that a water services institution must, where applicable, differentiate. And then it enumerates from A to F how it can differentiate, to who it can differentiate. And then, and C thereof says water supply services other than those specified in paragraph 4.1e and 4.1b. And all I'm saying is that this does not explain in totality as it would have been explained in 2015. But clause 4 talks to differentiation.
Yes, I would like us, Ms. Morocco, to confine ourselves to the powers of the minister in this regard.
Well, the powers of the minister would be that I'm the political head in terms of the Water Services Act. I must make sure that the Umgeni and other water authorities they abide by the constitutional obligation as far as access to water is concerned. That's the first issue. The second issue, I then have the right or the power. You're on mute. You're on mute. You're on mute. To me, I didn't hear a word.
No, I'm talking to myself, Ms. Morocco. I'm sorry.
Oh, okay. Okay. So, and really, the powers that that the minister does have are related mainly to the Constitution, to the Water Act, and to the Water Services Act. And arising out of that, the power to make regulations as provided in the Water Services Act.
In response to a question, Mr. Madonsela referred us to, I think, paragraph 3 or 4 of a document, and I cannot get that document now, which allows a water services board to differentiate having regard to different levels of service, geographical regions. Are you perhaps, because I would like your comment on that as well, Ms. Morocco, but I'm unable to locate that document immediately.
Page 198.
Page 1. Page?
198, volume 2.
198, volume 2. This is an extract of a pricing policy. And perhaps I should also have asked Mr. Madonsela this question.
Which paragraph are we looking at?
We're looking at paragraph 3 that Mr. Madonsela referred us to. It says a water board may set a single tariff for its whole supply. Now, this is obviously a summary prepared by Umgeni Water about its powers. Where is the source of this power?
You're probably going to have to ask Mr. Madonsela that question, I'm afraid, Justice Teron, because we, on our own, had thought that the Umgeni had this power derived from the norms and standards that were not promulgated. Because those norms and standards set out that this is actually doable, that they have the power to do so.
Now that the minister has realized that she didn't have that power under Regulation 7.4, has the minister specifically looked to see whether she has that power under another regulation?
We did. We looked for it, and the only one that the instruction that we have is that the only one that is there is the 2001 norms and standards. I'm not able to say to you there's any other.
Thank you, Ms. Moroka.
Ms. Moroka, please help me. I'm not too sure I understand. Can you read that clause 4 again?
Clause?
I think you said clause 4 of the 2001 norms and standards.
At page 337.
The one on which you sought to rely as the basis for the minister's exercise of the power to approve of the tariffs. Can you just read it again? I thought I heard something like the power being attributed to the Water Services Institution. I just want to be sure I understand. Just read it again, please.
Before we get there, Chief Justice, I need to be very clear. When we argued this case, we did not argue the case on the basis of the 2001 norms and standards.
Yes, no, that I understand.
Having said 15, having said that, the clause 4 indicates that in certain tariffs, that would be Umgeni, in certain tariffs within its area of jurisdiction, differentiate, and then it enumerates A to F.
No, just read it again as you did the last time you read it.
I said a water service institution may differentiate where applicable between the following categories. And A and B then sets out specific categories.
Okay.
C then says is a catch-all phrase.
Yes. Now, which part of it gives the minister the power to be involved in that exercise?
The minister is involved in setting the norms and standards. And the Water Services Act says you can't go and set standards that are outside of those norms and standards. Whereat I said to Justice Jafta, therein lies the inference that we, or the conclusion that we had the power, because we have the power to set the norms and standards. These are the norms and standards that we set.
Yes, I'm just trying to have us address legality. The minister cannot exercise power that has not been conferred on her. So I'm going back to the question that my brother Jafta asked. are you in a position to point us to the power that the minister purported to exercise in approving of the tariffs? Because we need to be sure of the status of the tariffs that were approved of the minister, and that should be in relation to the power that she purported to exercise or she purported to exercise. Are you in a position to say where we must look, where exactly we must look to locate the power that the minister was exercising?
I believe, Chief Justice, that you will not see a clause that says the minister has the power to approve. In those words, you will not see it. What you will see is Section 42 of the Municipal Finance Management Act. What you will see is the Water Services Act section, if I'm not mistaken, section 10, that says she has the power to set norms and standards. You will also see where it provides that no water service institution similarly placed as Mgeni, that's a bulk water service provider, can go beyond the norms and standards that have been set by the minister. Cumulatively, this means the minister has the policing power to see, one, that the tariffs are properly set, because the Water Services Act gives her the powers to examine whether there's been equity, whether profits are not, what profits can be used and for what purpose, what tariffs can be placed. Cumulatively, the only way you can read that is that she has the power to say this tariff is incorrect and this tariff is correct, because it's according to the norms and standards that I have set out.
Yeah, well, for what it is worth, in consultation with my colleagues, the heads of courts, I have the power to set the norms and standards in relation to the functioning of the courts, but I'm not too sure that those powers can be equated to those that you seek to attribute to the minister, but that is just by the way.
If I may, can I have a very short answer to that, Chief Justice? I'm very sorry about that. You don't have the power to say you can't go beyond these norms and standards. The minister has. The minister has.
No, I hear you.
If I may follow up on that, please.
Okay, then once you are done, let me know, my sister, because I've got other follow-up questions.
I'm sorry to interrupt, Chief Justice.
Yeah.
Ms. Moroka, if you look at Section 9 of the Water Act.
The Water Act, not the Water Services Act.
Yes, Water Services Act. It gives the minister power to prescribe standards in respect of, just for example, provision of water services. Now, before we look at Section 10, the power that the minister would have to approve tariffs, would that fall under a delegated power?
I do not believe so.
What kind of power would it be?
I think it's original power that derives from the Constitution and the Water Act.
Any specific provisions of the Constitution, Ms. Moroka?
Well, it's the right to access to water. And if you look at, if I may just say that, if you look at the preamble to the Water Act, you will find that the preamble talks to the fact that the minister is the custodian, and she's been given the authority by the Constitution to be the custodian on behalf of the people of South Africa, to manage access to water and to manage provisioning of water services to its citizens.
Let me take you to
that would be the Water Act.
Let me take you to my question, Ms. Morocco. Section 10. If I understand your argument on behalf of the minister, is that because the minister has the power to set norms and standards for tariffs and certain other powers, it's implied that she has the power to approve the tariffs. Now, if you look at Section 10.1, The power to set norms and standards does not belong only to the minister. She must do that with concurrence of the Minister of Finance. Does that mean, on your argument, that the Minister of Finance also impliedly has the power to improve tariffs?
No, that is not our argument. We say that the concurrence is that she is empowered to do this, but she can't do it alone. And then we cross-refer to Section 4 to say to you, no water service.
Interrupt you, Ms. Morocco. Section 10 says she cannot do it alone. She can do it with the concurrence of the Minister of Finance.
I accept that.
It must follow that whatever implied powers she has, on your argument, according to Section 10, that those implied powers would also rest at the foot of the Minister of Finance. So on your argument, must the Minister of Finance and the Minister of Water jointly agree on the tariff then? If they both have this power under Section 10, and you are relying on Section 10 to say the minister has that power, Minister of Water has that power.
Justice Theron, I am not saying you have to have regard to only Section 10. I have said you have regard to her powers under the Constitution, to her powers under the Water Services Act, to Section 10 with the concurrence of the minister, but over and above that to Section 10 in brackets 4. Because I submit that in Section 10.4, you cannot have superintendents over all of this if somebody is entitled to go beyond the norms and standards that you have set. Who is going to be the guardian of those tariffs if not the minister?
Those are my questions. Thank you, Chief Justice, for the indulgence.
Thank you, my sister. Ms. Morocco, as I understand your argument, the minister purported to approve of the tariffs in terms of the 2015 norms and standards, or is it regulations? Now, norms and standards, yes. Does it make any difference, or does it not make any difference that she relied on non-existent norms and standards? And are you going to seek to rely on the fact that the 2001 norms and standards do seem to authorize the differentiation? And are you legally entitled to do so?
The submission that I make in that regard, Chief Justice, is that we made an error. And therefore, we did not have the power as we had envisaged or as we had submitted in our papers. But that Umgeni relied on the correct norms and standards. That's the real high watermark of what we are saying. We relied on the wrong standards, the norms and standards. We should have relied on 2001, we relied on 2015. But we're saying Umgeni, in formulating its pricing policy, in differentiating, used, according to them, the correct standards. When we evaluated that, we evaluated on the wrong standard.
Okay, so your argument is not, well, it doesn't matter. In any event, we had the power in terms of the 2001 norms and standards. That's not your argument.
No, we would, I think it would be, and we do this, Chief Justice, as officers of the court, to bring to your attention the fact that we made a mistake. And we cannot sit here and submit that mistake is immaterial. I don't think it would be appropriate.
Okay. So should the position then be that there is no approval from the minister? Or should the position be that there's any approval from the minister?
I believe the position would be that to the extent that the minister approved on the basis of norms and standards that are non-existent, there is a problem.
Okay. Now, on the assumption that the minister was supposed to approve, but she in effect did not approve, what then is the status of the tariffs? Or what should be the status of the tariffs?
Which tariffs? The 2015 tariffs or the
ones that the minister purported to approve?
No, those have no status in law, Chief Justice. They're not there.
Okay.
What would be what we should probably be arguing, but again, it would not be appropriate, would be to say, well, in any event, if the minister didn't have the powers, as the questioning went, maybe then Mngeni had the power to approve, and that's the end of our difficulty.
And if the minister had the power and was supposed to approve, then what should we make of the approved tariffs that Mngeni seeks to protect?
Well, there are two issues to it, Chief Justice. If the minister didn't have the power, then Mngeni is scot-free. It can rely on the
If the minister had the power but didn't exercise it.
If the minister exercised the wrong power, then Mngeni would have to come back to the minister and say, come again, have a look at this thing and do the right thing.
Okay. So Mngeni must not succeed.
No. Mngeni can succeed. We can't succeed.
Thank you, Ms. Moroka. Thank you.
Excuse me, Ms. Moroccan. In the SCA judgment, at paragraph 19, I will read it out to you, where the court says, at the hearing, counsel for the minister informed us that...
I'm sorry, Justice Matopo. What page is that?
It's the...
Am I looking at... No, yeah.
The SCA judgment.
But you start
1007, paragraph 19.
It starts at 1006.
Yes, the paragraph that I'm drawing your attention to, or the line that I'm drawing your attention to, it's at page 1007. This follows from the debate that we've just had with the Chief Justice. I want to put a proposition to you which comes from the judgment of the SCA and solicit your comment. It says here, at the hearing, counsel for the minister informed us that the minister had accepted the validity of Mngeni's reasoning without investigating its correctness. One would think about what you've just had, the debate that you've just had. Accordingly, she accepted that if Mngeni's water decision on the tariff payable by CESA failed to be set aside, so did the minister's decision.
Justice Matopo, I think the second line that says accordingly, we accept the correctness thereof. We do not accept that we accepted that the validity of Mngeni's reasoning without investigating the correctness thereof. I don't think that's a correct submission of what happened and what we said. We said Mngeni gave us a decision, gave us a submission. We unpacked that submission, but we accept that if they were wrong, we fall by the fact that they were wrong. Not that we didn't investigate the correctness thereof. I think that is the wrong formulation. It's an incorrect formulation. And really, I didn't go into the Supreme Court of Appeals judgment because I think it serves no purpose today to do so once I've made the concession about our powers. But I take it that there will be things that are said about us here that are not correct, and this is one such instance.
Yes, Ms. Moroka, it looks like colleagues don't have quite questions for you. Is there a final submission that you'd like to make, or have you covered everything that you wanted to cover?
I have covered everything that I have to cover. I, again, really need only to say that we are embarrassed and we are apologetic about how all of this has unfolded. Thank you, Chief Justice.
Thank you, Ms. Moroka. Mr. Kemp?
Thank you, Chief Justice. Chief Justice, if I just make the initial submissions, having listened to the debate.
Maybe at this point, do you still need your 10 minutes without interruption, just to make sure?
Yes, I would like to just set out the main argument.
Thank you.
May I first say to you that what I say now is based on what I've obviously listened to. We stand by our heads, not heads, our written argument, our written submissions. But what we firstly say, this is an application for leave to appeal by the minister. From what has been accepted and conceded before you on behalf of the minister, it seems like the minister accepts that there cannot be prospects for the minister in that appeal because, firstly, there has been a major procedural irregularity in the minister's decision. And if I can refer you to the decision of, and I may have painful memories of that, of Zuma versus the NDPP in 2018. One is a 200 SCA at paragraph 93, where it became apparent that the national director had made his decision not to prosecute in terms of incorrect or non-applicable provisions of the law, and that was regarded as fatal to that decision. And the court refers to previous jurisprudence, including the Minister of Education versus Harris. It is our contention then that the application by the minister cannot succeed because in making the application there is a concession of a major procedural irregularity in the minister's decision. If I then can turn simply to the case that the CISA made, in the notice of motion, it was set out that what sought to be set aside is the decision of Ngeni Water, alternatively that of the minister if that superseded that decision. The case of CISA was that the decision by Ngeni was arbitrary and unlawful. And if justices, you look for a reference where that is set out apart from paragraph 7, which you have already had reference to, we will refer you that at page 104 to 105 of volume 1, we have stated in paragraph 13 that what Ngeni had done is simply an irrational, arbitrary, and indeed unlawful basis for singling out CISA. And the point was made that it was Ilembe's responsibility to provide water services in the Ilembe district, and because CISA is a link in the chain, this cannot warrant the extraordinary increase. And as this court have said, that the Umgeni Water has made this decision in terms of the Act, and a useful reference point is the judgment of this court in the restructures matter, and I'll give you the reference now, but you have said it on numerous occasions, and that was Minister of Justice versus SA Restructuring and Insolvency Practitioners Association. Its reference is 2018 5 SA 349 CC. And in paragraph 49, this court said that the Constitution proscribes arbitrary action and requires that every action taken in the exercise of public power must be underpinned by plausible reasons. Such reasons must justify the action taken. If action is taken for no reason or for no justifiable reason, it is arbitrary. Our case has always been that this decision was arbitrary. Our case was also, if we need and if we are forced outside Baja, we will rely on legality and rationality under that as well. What the SCA has done, especially if one looks at paragraph 50 of its judgment, it stated that the reasons that have been advanced by Umgeni has been found not to be plausible at all. For that reason, the court said that under Baja, the decision has not survived the challenge. The court did go further, and maybe at times rationality was perhaps used in the wider sense of being at all sensible in the context. It also found that as far as rationality goes, there is no way of defending the distinction and the differentiation drawn by Umgeni. And if I may just simply say to you that the core flaw in the Umgeni decision was it proceeded from the point of view that there was purely a contractual relationship with CISA, and accordingly, its conduct and its decision merely had to meet commercial factors. And in commerce, it's often so that commercial entities will not sell below cost. Sorry. And we say so because if one reads the papers, it's quite clear that in the state of Ilembe contention, is still said by Ngeni today to have no relevance. We say it is simply an incorrect process that had been followed. On anyone's version, it must be relevant that the services rendered are exactly those that Ilembe should have rendered, and Ilembe was under a legal obligation in terms of a statutory framework to provide water to the consumers, to do the reticulation. We then say, in this case, whether one approaches it from the perspective that when a state organ is in a contract, its obligations go somewhat further than just for commercial and private law considerations. And I can refer you to some authority in that regard in the SCA. But in this case, we say that it follows from the statutory arrangement and from the decision of this court in All Pay that when one finds a factual situation like the one that presented itself in this case, then it must at least be a relevant consideration, if not the predominant consideration, that CISA had stepped into the shoes of Ilembe in respect of that part and those consumers resident in that area. We say, justices, that
Mr. Kemp, the 10 minutes has expired. The minutes has expired.
Thanks.
You may proceed on that understanding.
Chief Justice. And if one looks at the papers, and I am going to ask you to look, if one wants to simply demonstrate it, why the process of MGNE was fatally flawed, I'm going to ask you firstly to look at page 520. That would be in volume 6 of the papers.
Mr. Kemp, I'm sorry. Before you walk away and move to the next point, you have just submitted that CISA replaced Ilembe by going into the shoes of Ilembe. I just want to understand, what does that mean? Does it mean then that CISA, a la All Pay, became an organ of state?
Yes, Justice, I would make that submission. For those purposes, it became an organ of state.
Okay.
Yeah.
And if it is an organ of state, does the judgment of this court in Gijima have any bearing on CISA being an organ of state, relying on PAJA? My understanding of Gijima is that organs of state do not enjoy administrative justice rights because the Constitution confers power on them, and therefore they cannot institute proceedings based on PAJA. They can only institute proceedings based on legality. So I would like to know if that is the position, was it correct then for the SCA to conclude that the matter was based on PAJA and therefore the decision is not rational, as seen through the lens of PAJA?
Yes. Justice, may I say to you that I commend myself for having the foresight to say to you for those purposes, because the submission we make is that in looking from the perspective of the Umgeni Water Board, they had to recognize the reality of the situation and to recognize that what the CSAR did was fulfilling the constitutional obligations of Ilembe. Yeah, but that does not mean that that was its only entitlement in that situation. It was also entitled when issues of profit was being raised against it to raise that the decision operates of that level against it also as a private entity. In other words, what I'm saying to you, there was a duality in Umgeni Water's decision. It did not make the decision solely on the basis that CSAR is an organ of state. It made the decision also because CSAR was also a private entity. We given that as one of the reasons. And I'm sorry, but the Umgeni Water can't have its cake and eat it and say, well, you're an organ of state, therefore I'm going to ignore any profit issue. If they wanted that, they should have made the decision on that basis. And then profit would not have come into it anywhere. But you cannot bring in an element that relates to the private identity of CSAR. And we have never disputed that CSAR is a private entity. In the fulfillment of the functions, it has stepped into Ilembe's shoes, and if it steps back out of those shoes, Ilembe will have to complete and step back into its old position and provide water in the concession area. That is my answer to that, and that is why I say that it is not sufficient to say that because they are organ of the state, they are now non-suited. Because sorry.
Yes, I hear the point, but I thought the tariff by Umgeni was imposed on CSAR only because CSAR has stepped into the shoes of Ilembe, not on CSAR as a private entity. Otherwise, I don't see the link between the exercise of the power by Umgeni of fixing tariffs, which do not apply to organs of state, but to private entities. So it was in that context that I am saying, therefore, CSAR is an organ of state. And as an organ of state, doesn't Gijima have a bearing on it coming forward to exercise administrative justice rights given effect to by PAJA when Gijima says that is not the case? Of course, In the pleaded case, CSA said Palja, alternatively, legality principle. That I understand. But I just wanted to clear up this issue of Palja.
Justice, can I venture something as well that my attention has been drawn to? As Gajima, it seems to me, says that the Act doesn't apply to organs of state seeking to review the decisions of other organs of state. But in this case, what I'm submitting to you is that CSA is not only an organ of state, and that is what is confirmed. What we simply say that for purposes of considering whether an increase must be passed on it, it must be borne in mind that they are fulfilling the constitutional obligations of Ilembe. And that is a relevant factor. That doesn't mean that it is lost locus standi and it cannot invoke Palja in that respect. And we say that that is the answer to what your question to me is.
Okay, your answer is that this matter is distinguishable from Gijima, or Gijima doesn't apply here because CSA is a private entity, even though for the purposes of performing the public function, it became an organ of state. Is that the distinction that is being drawn?
Yes, yes. And indeed, if you see why Umgeni says it's made its decision, it says it is because you are a private entity, you are a commercial entity. Mm-hmm. What we are complaining about is that that is not a good enough reason if you look only at that. And that was to a large extent what the debate was in the courts below, was about that issue, that Umgeni now said this was irrelevant. And may I say...
So to some, I'm sorry, Mr. Kemp, just so that I can understand your submission clearly in my mind. So to some extent, what CSA is saying is, I'm a private entity.
Yes.
Okay.
Yeah. In this, can I simply refer the court whilst in volume 1, this issue that I've raised about how Umgeni perceived the issue has a ripple effect throughout the entire process. There was a debate with my learned friend, Mr. Msela, over the profits issue, and he said that that was for CSA to raise. If I can ask you to look at page 30, you will see that what CSA says, and that follows on what it said on page 29. CSA says, well, Ilembe could not and cannot provide a better and cheaper service than we do, and there are sound reasons for that. It relates to capex to which CSA had access as a private body, and it points out on page 29 that the problem with state organs who are pure and solely state organs is that they have to budget, there is capex for the year, then it doesn't happen, and then they have to reapply for it, etc. It draws that distinction in paragraph 54.
Mr. Let me just interrupt you. It appears that my system is likely to give me problems. Just in case it does happen, my brother Jafta will carry on in line with the working arrangements that we have. I just wanted to make that point. Carry on.
Thank you. Then if one looks at page 30, you will see that the deponent for CISA says that I point out that Umgeni never even inquired about the aspect of profit. And one would have expected, if the minister was considering a price hike of 40% suggested to her, the very first question, when told that the rationale is because CISA is making profit, would have been to ask how much. That seems the self-evident question to ask. The paragraph goes on and says Umgeni's invocation of private profits as opposed to municipal profits has no factual basis and is mere make weight for a unfair and discriminatory decision. Now, if you go to page 263, that is in volume 3, you will see what the Umgeni Water answer to that is. Sorry, Justices, it's actually in volume 4. 263. No, sorry, 263. It is in volume 3, and you will see Umgeni Water says, I take note of the allegations contained in this paragraph. The allegation is that you have no clue, you haven't even asked about these profits. And I, however, reiterate that I do not see the relevance of the allegations in relation to the rationality or unlawfulness or otherwise of the tariff increases. And that is exactly the problem in this case. The stance that you are a private body and you're making profits, and that suffices for the decision to impose full tariff on you to cover our costs, is made on that basis. They're not interested in what the profits are. They're not interested in anything except that that is a fact that CISA is a private body and it makes profits. Now, as far as that is concerned, if one wants to look at what the realistic impact of that is, I ask you to go to volume 6 and page 520. Now, that is item 4.6 for benchmark tariff per customer. And one must bear in mind that in terms of a policy, this is only a guideline. If you look at table 17, you will see what the amount of what Umgeni refers to as cross-subsidization is. It goes over the page to 521. Now, then They summarize it in the table that appears in the middle of the page. If you go there as a convenient source, you will see that Ilembe's consumption is 15,000 kiloliters, nearly 16,000. CSIS is 5,000. If one looks at then what would happen is if CISA cannot or stops doing the work under the concession agreement, it would mean that Ilembe would then require 21,000 kiloliters. If one looks at what Ilembe's subsidy rate is, it's R3.874 per kiloliter. That would mean that one would move from what is below that. And that figure, I must say to you, I do not think that that is an accurate figure of 0.599, because it seems to me that the actual tariff figure there is wrong. And I'm not saying that in support of the CISA case. It seems to me that there was a mistake, so it would not be right to compare 387 subsidy with a 0.6 subsidy. But if one goes up, one sees that in the above document, the subsidy to CISA is reflected as 1.534 rand in respect of a kiloliter. One doesn't have to be a mathematician to conclude that if these services go back to Ilembe, it is going to cost Umgeni Water more money. They're going to suffer a greater loss because they subsidize Ilembe at a far higher rate than even the 1.5 rand for CISA. So there is something dramatically wrong with the reasons that this is so that Umgeni Water would not suffer financial distress. It seems if one takes into consideration that CISA is doing this in the stead of Ilembe, it seems that it is quite clear that it would cause Umgeni far more distress as far as finances are concerned. I did a little calculation that it comes to the difference in subsidization rate would come to an extra 12,509,640 rand, if that were to happen. So it does not seem as if the rationale and the aim to achieve financial stability is at all promoted by the decision.
Does that amount, Mr. Kemp, the 12 million amount, take into account the 10 million amount which could be saved if the tariff against CISA is accepted?
Yes, and Justice, what I did is I took What I did is I took the 1.5 subsidization rate and I deducted that from the 3.8 that applies to Ilembe. And I multiplied the 5,000 kiloliters with the difference between the two, which is about 2 rand per kiloliter. So that would mean that comparing the situation where there is a subsidy of 1.5 rand to CISA, if that responsibility is transferred back to Ilembe, it would cost Umgeni 12 million more than if they had paid the 10 million to CISA.
Okay. My understanding of Mr. Madonsela's argument was that in respect of Ilembe, because the area is bigger, there are other permutations in terms of which Umgeni would be able to recoup the losses. And he argued that in respect of CISA, it's a small area, there are no other options other than to increase the tariff. What do you say to that?
What I say to that, Justice, is firstly, one, that was not the reason given for the increase. That was simply not one of the reasons. It was a reason which Umgeni came up with in its answering affidavit. That was not the reason given when CISA was asked about it and asked what are the reasons. They did not give that reason. Secondly, Justice, if you actually look at the papers, you will see that Umgeni had not, at the time of filing that answering affidavit, which was in 2016, they even then had not yet come to any such agreement with Ilembe. They suggested they had come to some agreements with some other water authorities, but not Ilembe. They said that has not as yet happened. And I can perhaps ask my colleague to find that reference for you, but that is indeed what was said. So it didn't provide a factual basis for that to be concretely taken into account, and certainly it wasn't correct as far as Ilembe was concerned at the time that this decision was made.
The reason, I'm sorry, Mr. Kemp, the reason point I'm a bit lost by it. I thought the reason that was given was for increasing the tariff in respect of CISA.
Yes.
It was not the reason for perhaps treating Ilembe differently. So if that is so, the reason point I lose its potency, because what he says is that, look, we looked at the permutations in respect of CISA because the area was small. There's no room for recouping losses by other means. But in respect of Ilembe, there is, and I think he mentioned other municipalities as well. So I understood his argument to say, well, look, when it comes to Ilembe, if the function were to be performed by Ilembe, Umgeni would have a wider room in terms of which to recoup the losses which are made in respect of the area where CESA operates.
The Justice, that may even be so. What the point we're simply making is that was not the reason given to CESA, and it was not asked of them to respond to that aspect when that decision was made by Umgeni Water. What I'm submitting to you is that is argument. It was not one of the reasons, and that Umgeni is bound by the reasons it gave for that. It now wants to look at everything and all facts and to say, well, maybe this was a good reason for us to do it. But the point is, you did not provide that reason. You were specifically asked to provide the reasons. And that was certainly not one of the reasons. And secondly, we say to you, we have great doubts about whether that is feasible. And we say to you, from when the papers were filed, it was quite clear that that opportunity may have been a vague possibility, but it hadn't certainly not materialized as far as Ilembe is concerned. And just as we were dealing with the tariff hikes in a specific year. So it seems to us that that rationalization is not open to Umgeni Water. And as a matter of fact, there is considerable doubt. You will recall that no details were given of that. It is an open-ended justification. Well, maybe we can strike various deals with the municipalities on other matters related to water, and therefore perhaps reduce the subsidies to them. I will point out to you, my learned friend pointed you to page 617, it thinks, where in fact, that is not how the thinking was. If you look at page 617, it is stated that by reducing the subsidy to CESA, UW will have the ability to increase the subsidy to the more indigent areas. It wasn't that, well, we'll strike deals with them. What they were contemplating is that the subsidies would go up for other areas. And may I make this point, Justices? We do not even put forward the proposal that it would not be a proper differentiation in tariffs to recognize there are municipalities with more indigent areas. But that is not what was done here. You will see no analysis of how the various areas and the various bulk suppliers, what is the relationship between those indigent and those who are able to pay water tariffs and to pay increases in the water tariffs. There is no such analysis. CESA said, well, we essentially, if you look at that, we are the same demographic mix as elsewhere. And there is no sign that Umgeni Water actually looked at that and said, on that basis, we differentiate between the tariffs that you pay in this area and in other areas. We are simply saying to you, and neither the judgment in the court where this started, nor the SCA judgment anywhere suggest that Umgeni cannot differentiate, nor does it suggest that a differentiation based on the fact that that bulk purchaser has to provide for a large number of non-paying end consumers.
Mr. Kemp?
Yes?
Excuse me, Mr. Kemp. On the impact of the increases, is CISA allowed to increase its tariff on the basis of the increase that was approved by the minister? If not, was that brought to the attention of Umgeni during the presentations on the proposed increase?
The fact that CISA, the increases are determined by Ilembe municipality has never been said to be incorrect. It is incorrect. It is correct. CISA has said that. And Umgeni must know that, Justice. It has a copy of the concession agreement. You will indeed recall that they had indeed tendered on it, and because they couldn't give the municipality a better offer than CISA, they seem not to have gotten that tender. So it seems on the facts that it's very clear that Umgeni Water knew that CISA could not turn around and levy a 40% increase on the consumers. You will recall that the evidence is indeed that the municipality passed an increase for the year in question of 17% in water tariffs to its consumers, and they approved a 15% increase for CISA. And that is the evidence. And it is indeed so that CISA could not just say, well, we just pass this increase on. Clearly, Ilembe had a say on it, because if you are a consumer in that area, and public perceptions do matter, as this court has held on a number of cases, you say, well, but what's wrong with my municipality? Why must I pay all this much? And they are actually the ones who have to supply the water. So Ilembe is in no way going to approve a 40% increase on the monies that a consumer had to pay, and have the spectacle of person living this side of the road in that area within the concession area have his 1,000 rand a month increased to 1,400, and his neighbor across the road have his increased by 80 rand, or whatever the increase was, but it was 8.3% what Umgeni initially proposed for all other purchasers of bulk water. And we say that actually the matter is a very simple one. You lost sight of the fact that CISA is not this entity who buys this extra water and uses it in some process, it supplies for consumers. And you had to consider what the effect on those consumers were, because what would now happen? They would, at least for a number of years, then be exposed to huge increases to try and make up what the increase in payment by CISA was. It seems to me, Justice, that Umgeni Water knew that, but they chose not to take that into consideration. And sorry, can I then move on to another issue? What we then say is we have in this hearing, we have heard the applicant, and there's only one application for leave to appeal before you, because it seems to us that you've ruled on the other application for leave to appeal. If that leave to appeal by the minister cannot succeed, and it seems that it cannot on the facts presented to you, there is indeed nothing to consider as far as Umgeni Water is concerned. There has been a final judgment. We say that they have settled that issue between us in a settlement, and we say that is the end of the matter. There is no dispute between us and Umgeni Water anymore. Umgeni Water says to you, but they sort of settled, they entered into that agreement because they thought that the matter was finally over. They didn't take into account the fact that the minister indeed still had an application pending before this court. May we say...
Mr. Kim, can I interrupt you on that point, please?
Yes.
Is it for this court to make a determination on that settlement agreement?
No.
Really not.
It is
Maybe
not,
that's a matter for another court.
Yes,
if necessary.
Yes, but we point out if indeed the minister's application is not sound, then it really doesn't matter. That mistake that they may have made is entirely irrelevant. And in the papers before the court, we have pointed out that they were well aware when they settled that the minister's application had not yet been ruled on. So,
yes, but then I think that, you know, I just need a short answer. It's then not the function of this court to determine that issue, the effect of the settlement.
No.
So you can move on to the next point.
Thank you. Then I will be brief about this, and I will say that in this case, the Umgeni Water rather took the stance that we're not caring about the aphorism, if it ain't broke, don't fix it. They adopted the stance, rather, if CISA goes broke, we will fix it. And it seems that there's no other sensible way to explain what they did. And I do know that I'm now transgressing onto saying, well, there may be another reason why they did what they did, but I have shown you on the record of decision why it simply does not make financial sense to promote the viability of Umgeni by imposing this 40% and running the risk that this may result in the breakdown of the concession agreement. We then say that insofar as the profit reason was part of the Umgeni reason, they certainly did nowhere close enough to investigate that issue properly. In terms of the Act, they are quite entitled to ask a water service provider for relevant information. It is one of the powers given to a water board. They did not do that because, as they say, it was really irrelevant to them what that was.
Mr. Kemp, I'm sorry.
Yeah.
The issue of mootness, is it not your client who raised it?
About the issue of mootness, we say, as far as that is concerned, we have a settlement agreement with the second.
No, I was asking whether it was not your client who raised that issue.
Yes, we did raise that issue because...
And you are saying it's moot because there is a settlement.
We say it's moot for two reasons. And what I say now, I say one, the minister's application for leave to appeal cannot.
No, I understand that once the minister's application for leave falls by the wayside, as I understand the submission is that there is no application for leave remaining. That I understand. But I was probing the issue of whether or not we can consider, take into account the settlement agreement in circumstances where it is your client who advanced the mootness point relying on the settlement agreement. I don't follow that submission.
Justice, that submission was made because the Umgeni Water was latching on to the minister's application. And we said that as far as us and Umgeni is concerned, the matter is in any event moot.
I'm sorry to interrupt you. I'm sorry to interrupt you, Mr. Kemp. What I didn't understand is why should we not consider the basis on which your client rely in saying that the matter is moot? Why should we not consider that?
The reason why we said that, Justice, was there is a dispute about that. This court normally does not, except in exceptional circumstances, deal with factual issues and factual disputes. We put that and say to you that therefore we would have considered that the response would rather be that this is a matter for another court than to say this court will decide it. If you decide it, Justice, then I would submit to this court that it is fairly clear that there was a settlement. And secondly, that the reason advanced by Umgeni that they were misled about it is simply not true. The fact of the matter is Umgeni knew full well that the minister also had made application and that the order of this court related to Umgeni Water's application, not the minister's. And it may well be that they thought it was unlikely that this court would give the minister leave, but that is not a matter that disturbs settlement agreement. That is their high water mark of their case, that they did not consider that fully that this court may give leave to the minister, and that there may still be a chance that this court may say that the decision is valid and enforceable. That is no reason to impugn a settlement. It is one of the risks that you calculate when you do a settlement, that you would rather not want a court decision and risk the implications of that, and you would rather settle the matter and have certain certainty and deal with other matters. It is not a ground for impugning a settlement agreement. So if you want to decide that issue, and if this court decides it, we say it must decide it on a basis that there was a settlement.
Yes, I understand, Mr. Kemp. So, no, I was going to say, I understand. I was making another point, though, not the point that the settlement agreement itself is before us to determine whether it was valid or not. The question was, in the context of mootness, if we reach mootness, I understand the other point, submission that you're making about the minister's, the fate of the minister's application for leave. I understand. But if we were to reach mootness, it seems to me we were to be required to evaluate the basis of concluding that the matter is moot. Otherwise, we can't say the matter is moot if we don't evaluate the basis of mootness. But that evaluation, as I understand, cannot go to so far as setting aside the settlement agreement, the validity of which is not before us.
Yes. Okay. I accept what you put to me, Justice, and but the point that when we made that point, we certainly didn't anticipate that the response would be, well, we're not bound by the settlement. And it is not a settlement. So when that point was first raised by CISA, it was on the basis that it's common cause that there was a settlement. CISA, Umgeni has come back and said, well, no, it isn't common cause. We don't regard it as a settlement. But it certainly explains why Umgeni Water was faced with mootness when it had, to all intents and purposes at face value, have settled their dispute. They had an adverse decision of this court on their application for leave to appeal, and then they, in response to that, there was a settlement. So it seemed to us that as far as their matter is concerned, there was nothing left to debate between the parties.
Thank you.
Mr. Kemp, perhaps I misunderstand Caesar's argument, but I understand them to be saying more this. What the parties agreed to in the settlement agreement was something that would flow naturally from our refusal of leave to appeal. So it was not, a case of give and take and then culminating in a settlement. It's more a situation of, this flows naturally from the fact that we as CISA have not been granted leave to appeal. And therefore, the substratum of the argument is that if that be the case, if for whatever reason, that judgment that led us to settle on what is a natural consequence of a judgment of this nature should also automatically fall by the wayside. That is how I understand the argument, but maybe I misunderstand it. What would your response be?
My response to that would be that insofar as that was the premises of that agreement and it followed, I accept it followed as a result of this court's refusal, the fact of the matter is that this court's refusal still stands as a judgment. And unless you as a court, for some reason, is convinced that it's wrong and you have the powers to overturn that decision of yours, it seems to me that the
Can you please just answer the point of substance? Leave aside the question, do we have the power or don't we have the power to set aside? Can you please just answer the point of substance?
The point of substance is that it is our submission that that issue, that it followed from a judgment naturally by this court, is unchanged. That is still the position. The fact that that was one of the facts that was taken into account was a proper fact to take into account at that stage. It wasn't that this court, that somebody in this court, some, let's say, official or secretary or whoever has sent that order in error. So we say it matters not. It doesn't afford a ground to impugn the settlement because there was no mistake about that.
I will leave it be, but that does not answer my question. I will leave it be.
Sorry, Justice, maybe I misunderstood your question. If you just pose it to me again, I will obviously try my best to answer your question. But my answer was simply, the mistake was not as far as the refusal of the leave to appeal was concerned. The mistake that has been advanced was the mistake that they didn't give sufficient attention to the fact that the minister's appeal was still at that application for leave to appeal was still alive at that stage. And my answer is simply that it's the first one that matters, not the second. I do not know whether that answers your question, but that is
my focus is more on the nature of the settlement. Is that something that would be a natural consequence of the refusal of leave? And that has nothing to do with whether or not we, as we sit here, are in a position to set aside our refusal of leave. So the two are connected. I'm interested in the nature of the settlement. Is a settlement the sort of thing that would have flowed as a natural consequence from our refusal of leave? Take this example. Somebody has a judgment sounding in money against them. It has gone through all the appeal processes, so no chance of it being changed and no chance of even a reconsideration. It's final. And then that person says to the adversary, I have serious cash flow problems, so I will not be able to give you any money. But to avert a situation where the sheriff comes to my premises and picks and chooses, let me give you A, B, C, D assets, which I believe will cover my indebtedness to you. And the judgment creditor agrees to that. Speaking very loosely, one could regard that as a settlement. But point is, the judgment debtor just had to pay. It's a natural consequence for the judgment debtor to pay.
Yes.
So my point was, if I do not misunderstand the argument of Caesar, I think they are saying that We entered into this quote unquote settlement purely because it was a natural consequence of the Constitutional Court's refusal of leave. So my question is, do you accept that or don't you?
I accept that in the sense, Justice, whenever, say for example, there's an order of court that there must be a division of an estate, the parties would, if I have any sense, get together and say, well, how are we going to divide this estate? Say there's a common estate. But whilst I accept that meeting and discussing this would be a natural consequence of that, it is not an inevitable consequence. If they didn't agree that with us, then the law would basically just have taken its course as far as that is concerned. So I do not see, my submission to you is simply that I do not see, whether one calls it a settlement or any other agreement, why that was not an agreement to have what has been finalized between us put into practical effect. And whilst we have said nothing about Umgeni Water being here and arguing, the fact of the matter is we consider that the case against them is final and concluded. And the fact that they settled with us is just a practical way of giving effect to that. Justice, that is the best I can do to your question. Thank you. May I just have a brief moment, Justices? Justices, we then say that the application for leave to appeal should be dismissed. We say it should be dismissed with the cost of 2 counsel. And about that, we simply say what is source for the goose is source for the gander. The applicants suggest that that is the appropriate order, and we would say that the appropriate order would be that of a cost order against both Umgeni Water and the Minister jointly and severally, including the costs of 2 counsel. It is quite clear that if the Minister was here in her own capacity and as the Minister probably did today, looking after the Minister's sides of things, we would have a much shorter, hearing. Justices, unless there's something that you wish me to do. Yes.
Before you take your seat, but you're already seated, please, how do you see Umgeni Water's role here today in the application of the Minister for leave to appeal?
Justice Taron, our submission is that they have no right to be here. They have sought an audience with this court, like any other litigant, on the basis that they must prove the necessary requirements about interests of justice, reasonable prospects, all that, and they have already failed. Technically, they are the second respondent in a minister's application, but that doesn't give them a right to re-argue what they have already suffered a rejection by this court. They are trying to open up the prospects of reasonable success debate with this court. and they actually have no basis for that. At best for them, they could have provided support for the minister's argument. But the minister's argument has come to nothing. So it seems to us that as a matter of law and as a matter of specific fact in this case, that Ngani Water, once that happened, the submissions they make is submissions that have already been considered by this court and have already been turned down. And that is our submission about Ngani Water's role here today.
Mr. Kemp,
yes.
I'm sorry to interrupt you. On the assumption that we are with you, that the minister's application for leave to appeal is fatal for the reasons you submit, where does that leave the application brought by Ngani Water?
Well, that application of theirs must be premised on the minister being given leave. I do not understand on what basis they say that the decision by this court not to grant them leave must be overturned. As I've contended earlier, it is not a case where this has happened by accident. We do understand that different judges read different papers and form different opinions, and that may be unfortunate, but that is indeed how the system and the system of precedent works. So it seems to us, if I came here and said this was a complete mistake, somebody had put this refusal on that case number by mistake, it would have been different. But that doesn't seem to us to be the issue here. It seems that their application was considered on the merits and it was refused. I am quite certain that there may be some extraordinary circumstances where this court may visit such a decision of itself and then say it's clearly wrong, and we wish now to overturn that and to give you a right of appeal. But this certainly is not one of those cases. Indeed, we have, as we have debated this issue today, it has become more and more apparent that the previous process was flawed and deeply flawed as well. So we do not consider that it would be in the interests of justice to indeed revisit what this court has already decided, namely that Ngani Water does not have prospects of success. And it would be a very odd thing if whenever this court makes that finding, that the litigant can say, well, we still want a hearing and we want to re-debate that with this court.
Let me put the question a little differently, Mr. Kim. On the assumption that we are with you regarding the fact, your submission that the minister's appeal must fail, what is the legal status of the application that has been brought by Ngani Water? Can we consider that application?
My submission is just as new. My application, my understanding is, and please do not be critical if I also, if I just put it loosely, I accept that this court can do just about anything. But that would only be in extraordinary circumstances. There are no extraordinary circumstances in that application. You must simply say that it was not one that is brought within the ordinary jurisdiction of this court, and that you do not grant that application. You must simply dismiss that application. That is our submission.
My last question, Mr. Kemp, and I will also ask this to Mr. Madansela, but it might be fair to give you an opportunity to consider it. At page 191 of the record, volume 2, we see the water pricing policy. Now, Umgeni Water has placed great reliance on its powers in terms of the pricing policy and its powers to differentiate between users. At the foot of that page, it says the pricing policy is informed by, amongst other, the national water policy. And if we go over the page, draft revised section 10, regulation on norms and standards for tariff setting. Now, we know from what Advocate Morocco told us that the minister could not rely on those norms and standards. Could or can Umgeni Water rely on the norms and standards for informing its pricing policy? And if Umgeni Water could not rely or cannot rely on the norms and standards, what does it do to the legitimacy of its pricing policy in terms of which it made the differentiation?
Justice Ron, I do not have a problem that Umgeni Water could look at that, because I say by looking at it as a draft section. So they can look upon that. And justices, it has never been the case that the Umgeni Water as a water board cannot differentiate in tariffs. It is their choice to do so, but when they do so, they must do so for plausible reasons. This case was never about anything else than you did not have plausible reasons for the differentiation you made. It was never the case that CISA said you cannot differentiate. What CISA said, you cannot differentiate on these grounds that you have told us led you to this 41% increase. So to put it to you, it may well be that they have this policy and then those draft norms and standards do not become part. And they may well then, if there is a pertinent issue about that becoming the norms and standard, they may well have to revise their policy. But it doesn't seem to me that the fact that they are relying on a draft norms and standards, that per se disqualifies their policy.
Following on my sister's question, may I just ask you this? You seem to submit that Umgeni can differentiate on a basis. In the light of the minister's concession, can Umgeni then differentiate on the basis set out in the norms and standards which are not relevant to the time of the decision?
Well,
you see, you've made the concession that they can differentiate, but can they differentiate outside of the ambit of the 2001 regulations?
Justice, you asked me a difficult question for a very simple reason. It is a difficult question whether Umgeni Water can perhaps say, well, there was this document whereby the minister set out what she intends adopting, and we want to make that part of our policy. I'm not sure that that would not be permissible. But what is impermissible is that if there are a guide, it is impermissible to deviate from what is in fact the guide and binding. And that is something that perhaps we haven't debated clearly, but it seems to me that if one looks at the Section 10 of the Act as well, it says no water institution may use a tariff which is substantially different from any prescribed norms and standards. So what one would have to do would be to compare the draft policy with what is actually the prescribed one and see if the deviation is significant. If it's significant, then it cannot serve as a guideline for Umgeni water. And I do not know whether that answers your question, but it seems to me that that is the correct legal position, that if there is a deviation or significant deviation, then it means that Umgeni Water is taking their decision and their administrative action is not in accordance with the legal provisions that govern such a situation. And I'm sorry that I can't answer your question more accurately, but it would require me to just look at the draft policy then and now, and I haven't made that comparison as yet.
Mr. Kemp,
sorry.
Yes, on that very question, if we look at the norms and standards for 2001 that Mr. Madonsela referred us to in volume 4, particularly page 337, clause 4.
Yes.
It speaks to differentiation and it lists the basis upon which Umgeni Water could differentiate, and the bases listed in A to F and even in clause 4 subsection 2, as far as I can see, does not relate to the service providers or the municipalities.
No, it does not. May I say, Justice, I'm sorry if I interrupted you, but it seems to me that the framework contemplated by the legislation would have been a water board, then a water supply authority, and then a water service provider. So the bulk providers in the paradigm case would have been municipalities. And that obviously is not in this. The water services institutions talks here about water services provided to consumers and other users within its area of jurisdiction. It seems to me that what this sets the guideline for is for the services and differentiation as far as consumers are concerned.
Yes, but it doesn't deal with differentiation, as you've said, between bulk providers.
No, it does not.
So we have to look elsewhere for Umgeni Water's authority to differentiate between bulk providers.
Yes, may I just have a quick look to see if I can answer you. if one looks at 31.2b, that seems to be the only source where that may come from, Justice. 31.2b says a water board may set and enforce general conditions, including tariffs for the provision of water services. It seems to me that that may be where Umgene's power to set tariffs would come from.
Yes, but the point I was looking at, Mr. Kemp, whether the reliance on the pricing policy and the norms and standards supports the argument that the pricing policy or the norms and standards gives Umgeni Water the authority to differentiate. That authority, as you pointed out, might come from Section 31.2b of the Water Services Act.
Yes. My answer to you is it doesn't come from that regulation.
Yes, because it seems to me that in the papers, Umgeni Water has said that they derive their authority, part of their authority to differentiate from clause 4 of the norms and standards. But I leave it there, Mr. Kemp. Thank you very much.
Thank you. Justices, unless there's anything else, those are our submissions.
Thank you, Mr. Kemp. Mr. Madantela.
Thank you, Chief Justice. Might I, with your leave, Chief Justice, ask that my friend, Mr. Mahabir, should deliver the replying address.
Thank you, Justices of the Court. Thank you, Justice. Thank you, Justice. Thank you, Justice. Thank you, Justice. Thank you, Justice.
Come here.
Apologize for that. Justices, the first point is in relation to the concession made by the Minister. We believe that the Minister's application cannot fail because the concession, firstly, is not material to the outcome of the case, but to the extent that CSER contends that the Minister's application for leave to appeal must fail, we revert to the 2001 norms and standards, which empowered Umgeni, at the very least, to differentiate where applicable according to the factors set out in A through to F. These are not the only factors. At the very least, however, it was entitled to differentiate on these bases. But in any event, Section 4.1c at page 337, which is at volume 4, empowers Umgeni to differentiate on the basis of water supply services other than those that refer to water supply services to households. We know that that's not what applies here, and the industrial use of water supplied through a water services works. We know that that does not apply here.
But does that then not make it a very vague situation, completely vague?
The application of the words "at least" it follows from that Umgeni is allowed an exercise of a discretion with regard to these factors at the very least. So it is a wide discretion, and as long as that's not applied incorrectly or impermissibly, which we say did not occur in this case, then Mgeni has the power to differentiate as it has done.
Ms. Mahabir, the differentiation in clause 4, does that not relate to the category of water services as opposed to water providers? For example, you can differentiate between water used by households, industrial water, sanitation, water used for sanitation. So those are the categories that clause 4 relates to in terms of imposing different tariffs.
Yes, Justice, that's correct.
Is there a clause in the norms and standards that sets out the basis for differentiation between water service providers instead, as opposed to categories of water services?
That would go, Justice, to the definition set out in the Act. And that paragraph, I beg your pardon, that section 33 Madam Justice Turan, you mentioned the conditions under which provision of services may be set. And at 33.1, those factors include the determination and structure of tariffs. These conditions may be set generally or agreed to specifically under section 33.2. And going back to 31.2, B, a water board may set and enforce general conditions, including tariffs for the provision of water services. What we're saying is that the Mgeni Water may choose how it sets out the tariff according to a general position, which is what it happened in respect of the municipalities, because what Mgeni said was that we can offset losses against other permutations of our relationship. But in the case of CESA, where that opportunity did not arise or could not arise, Mgeni had to look outside that in a creative manner. And the way it did so is explained at pages 75 and 76 of the record in volume 1. There were 3 reasons provided there. The first is the break-even principle, which says, where Mgeni says that its policy strives to break even with all its customers within its area of supply. But because CESA only draws water from one system, whilst other customers draw water from the same system are also able to draw from other systems, Mgeni is not able to break even with CESA on that basis. And what it says here is that it's rather unfortunate that with CESA, there are no cheaper systems. So Mgeni did consider that as an avenue to explore in terms of setting the tariff for CESA. The second reason it provided was that the municipal customers are related parties to Mgeni under the intergovernmental system. So they would be able to work together to break even and not for profit, whereas in the case of CESA, their profits would be channeled directly back to CESA. That's not controversial.
Ms. Mahabir, I may have missed it. I thought that my sister's question was in relation to clause 4 of the 2001 norms and standards. The Water Services Institution does not cover Umgeni. Now, the question is whether a water services institution refers to a water services institution as defined in the Act. And when you look at the Act, it says water services institution means a water services authority, a water services provider, a water board, a water services committee. So the question is whether when we're talking a water services institution under the norms and standards, are we referring to the animal defined in the Act? If it is, then Umgeni would be covered, isn't it?
That's correct, Justice. Indeed. Thank you, Justice. Returning then to the reasons, the last reason, sorry, we were dealing with the second one. And again, Umgeni explained to CESA that because CESA enjoys its water supply from the Hazelmere system through the North Coast pipeline, and then derives a profit for that, which cannot then be used for anyone else but CESA, that avenue was not available to Umgeni. And then over the page at page 76, we get to the point about the better level of service that CESA enjoys as a result of the arrangement with Umgeni on the one hand and Ilembe on the other side, on the other hand. And Umgeni explains reasonably that the system that CESA draws water, its bulk water from, is from the Avondale Reservoir and Honolulu Reservoir. And Umgeni has itself invested in that infrastructure. The total cost to Umgeni as a result of that was approximately 105 million rand. And what Umgeni was saying is, as a result of that, the profit that you are receiving is being subsidized to some extent by Umgeni, and we're entitled to take that into account as a further consideration. The other point, Justices, relate to a few minor housekeeping points. The learned friend for CESA mentioned that the impact on the other municipalities was not part of the record, and he referred the court to page 103, I beg your pardon, to page 180, paragraph 144.2. That was an unfortunate reference to the minister's answering affidavit, not CESA, not Umgeni's. But to that extent, the reason that there was no analysis of the municipalities that was presented to CESA was because it was explained to CESA that actually the municipalities, the engagement we had with the municipality did not feature before CESA because that presentation was limited only to CESA. And if I may take the court to paragraph 17 in volume 1. In terms of the manner in which the oversight was applied by if the court could bear with me, it's in Umgeni's affidavit. At page 126 in volume 2, paragraph 17, insofar as the minister's role is concerned, the oversight that is in place to direct and approve the tariff set by Umgeni is explained there. It's a collaborative effort whereby Umgeni engages with its customers, in this case with the municipalities, with CESA. It also engages with the South African Local Government Association, which has an interest, National Treasury, and with the minister. So the oversight that's in place here is significant and does not rely entirely on any error that the minister may have made in terms of what the correct norms and standards were that would apply. Pardon? That takes us back to the original point that the concession made by the minister is not binding on the court, and it does not damage the minister's application for leave to appeal to the extent that CESA has submitted.
Where does the minister's power to approve come from?
It's implied, and that's what we explained at paragraph 17 of the answering affidavit. It's not expressly spoken of, but we say that the minister's power to approve the tariff increases is implied.
From what exactly?
From section 42 of the Municipal Finance Management Act, where it's spoken, if I could refer the court to Annexure I beg your pardon, Annexure G at page 89 of volume 1. It's of the duty of Umgeni to submit any proposed price increase to the minister. It's at paragraph subsection 4. Well, the Act goes further into what must comprise the submission made to the ministers. And then it says at subsection 4, the executive authority of the organ of state must table the amendment and the documents referred to under the submissions or in Parliament or the relevant provincial legislature as may be appropriate. And then under subsection 5, unless approved otherwise by the minister, an amendment to a pricing structure, which is tabled in Parliament or the relevant provincial legislature, must not take effect other than in terms of the dates set out in the subsections. Granted, the minister that's spoken of here is the Minister of Finance. We're saying in relation to water, it would be a joint oversight that's applied by the Minister of Finance together with the Minister of Water Affairs.
Ms. Mahabi, I'm sorry. So you say the minister that's referred to in 42 sub 5 is the Minister of Finance and not the Minister of Water?
Yes.
So it's the Minister of Finance that must approve a pricing increase?
Yes. And we had that approval.
Is the Minister of Finance the executive authority in respect of the Department of Water and Sanitation?
Under the provisions of section 42(1)(a), the Minister of Finance is the executive authority. And that's in relation to, if one goes back to 42(1), if a national or provincial organ of state which supplies water to a municipality or municipal entity for the provision of a municipal service intends to increase the price of such resource for the municipality or municipal entity, it must first submit the proposed amendment to its pricing structure to its executive authority within the meaning of the Public Finance Management Act and to any regulatory agency for approval if national legislation requires such approval.
Yes, but isn't it that the Public Finance Management Act defines executive authority in relation to the Department of Water and Sanitation as the member of cabinet who is responsible for that department.
Yes.
So how can it be Minister of Finance here?
The Minister of Finance engages with the decision and approves it from an accounting perspective as to the setting of the price. The Minister of Water Affairs considers whether the price is arrived at with consideration to the norms and standards and provisions in the Water Services Act. So it's a joint a process which is conducted.
No, but we're talking in the context of 42(1)(a). Says it must submit the proposed amendment to its pricing structure, A, to its executive authority within the meaning of that in the Public Finance Management Act. And if the Public Finance Management Act defines the executive authority as the Minister of Water and Sanitation, it can't be Minister of Finance, because A tells us is the executive authority as defined in that act, not in this one.
Correct. The Minister of Water Affairs authority is to be found under section 42(1)(b) as the regulatory agency. One A, I beg your pardon, and the Minister of Water Affairs is the regulatory agency for approval under sub B. The Minister of Finance then, once he approves the pricing structure, then what 5 says is sets out the timeline that must follow when the increases take effect. So it's a question of the timing under subsection 5.
Reference to Minister
So once the Minister of Finance approves.
Okay, sorry,
yes,
continue.
Once the Minister of Finance approves, then under subsection 5A, the amendment takes effect on or before 15 March in any year, or after the 15th of March in any year, does not take effect for the affected municipality. So it's a question of the structure by which an increase may unfold. Yes, Justice Chiki. Sorry, Justice, you're on mute. Yes?
Yes. I'd like some clarity on a different issue. That is now your application for direct access. Because it bothers me. What bothers me is that you are applying for direct access in this court. And one of the remedies you ask in paragraph 3.1 is that we should set aside the settlement agreement, which you allege was erroneously concluded by the parties. And that seems to me to be one of the orders that you seek in your application for direct access. What bothers me is this, and maybe I am wrong, is whether, in fact, the circumstances surrounding the settlement or the conclusion of that settlement agreement are not, in fact, in dispute. And whether, if you agree that, in fact, there's a dispute of fact concerning that matter, whether this court can then grant direct access to you concerning that issue.
Thank you, Justice. On that point, we only arrive at the application for direct access if this court agrees that the settlement agreement was in full and final settlement of the entire dispute. Based on the debate that unfolded shortly before my address to the court, it's clear that what occurred as a result of the settlement of the refusal of Umgeni Water's application for leave to appeal was that the parties needed to deal thereafter with the consequences being that there was a sum of money that was being held in trust by CSIR's attorneys and what was to become of that. But if the court agrees that that document, the accounting exercise which unfolded and which is set out in Annex SM2, does not comprise a settlement of the dispute, then we don't arrive at the application for direct access. And that's the basis on which we have contended for it to be brought on a conditional basis only. To the extent, however, that we do engage in a debate regarding the application for direct access, the point we make is this: the parties are here. We are dealing with important issues relating to the fettering of public power on the part of Umgeni to set tariffs within certain parameters. And we're not dealing simply with setting of a tariff in respect of an organization which has service delivery objectives. We're dealing with an entity which will enjoy the profits entirely for itself. That's an important public interest perspective for the court to bear in mind. And it's in the interest of justice, therefore, that the court allows the application for direct access if the court does agree that with CSIR that the entire dispute was somehow resolved or settled on the basis of the documents comprising SM2.
Excuse me, Mrs. Mahu. Doesn't what you are now seeking seeks to undo what this court has decided in May when it dismisses the application for leave to appeal? And if it is so,
I missed the second question, Justice Mutolo.
I'm saying if it is so, is it permissible for Umgeni to do that?
Justice Matopo, Umgeni Water is in this court as a party to the minister's application for leave to appeal. We have substance to add to the debate before the court. What we're seeking to undo is not, I wouldn't go as far as saying we are to some extent seeking to undo the shutting of the door on Umgeni's application as it occurred. But we have
excuse me, isn't it correct that you cannot arrive at setting aside the settlement agreement in the face of a court order that says your application is dismissed?
There's no settlement. Then there's no settlement, and that's been our original point insofar as the mootness argument is concerned. There has been no settlement.
But that's what you are approaching this court for, to say, set aside the settlement agreement. My sister Chikli has put to you that what you are now seeking us to do, if one looks at your application, there is a dispute of fact, in the sense that you are contending for A, that there has been a misapprehension, and CSIR is contending for a different interpretation. And in essence, all what she was putting to you is, are we in a position to make that determination on your prayer 3 of the notice of motion? Can we make that determination? In other words, can we resolve that dispute of fact, unless you were to say to us, it is not a genuine one, and then we must take a robust attitude and say, deal with it, But you don't seem to be saying that unless you're taking the invitation now.
What we're saying, Justice, is that it's not a dispute of fact. It's not a genuine dispute of fact. It's a question of interpretation. And in that, one must bear in mind the context in which the discussions unfolded between Umgeni Water and CSIR at the time. It was as a result of the belief that was held that the matter had come to an end. Had Umgeni been aware that there were still side conversations that were occurring between CSIR and the minister and CSIR and the court that somehow kept the dispute alive, then the situation would have been completely different. But even on its own terms, the documents that had been annexed to Umgeni's affidavit set out clearly the context in which the discussions occurred. And what those documents set out is that there's no settlement that's spoken of. What's spoken of is payments, offsetting certain amounts, and how to deal, the method of dealing with the monies that were held in trust by CSIR's attorneys. It was not a settlement agreement.
Are you and CSIR at Eden on what the purpose of that agreement is?
Justice, we say that the entire context has been explained in the documents, where CSIR was coming from, where Umgeni was coming from at the time. It was, we have these funds, they have been collected from the public, we need to do something with them. In the meantime, Umgeni was liable to, I beg your pardon, CSIR was liable to Umgeni for its consumption of water. So there was an offsetting that then occurred. That's what the documents say. The documents at no stage say by Umgeni, we concede that this matter has now come to an end, or that we're negotiating somehow that the matter, that the dispute is resolved on a full and final basis.
Okay, perhaps a different way of asking this question. What would we have to do in order to grant your prayer in 3.1 of making a firm finding that the settlement agreement was erroneously concluded? What would we have to embark upon as a court of last instance in order to arrive at that conclusion that you want us to arrive at in 3.1?
Justice, my submission on that is that we require the court to do no more than consider the documents that we advanced in support of our application, from which it will be seen that the parties were engaging in an accounting exercise, no more and no less than that.
Ms. Mahabir.
Go ahead, my sister.
Thank you, Chief Justice. Ms. Mahabir, please may I refer you
What's her name?
to page 198
Okay.
of volume 2. Your leader referred us to paragraph 3 that says a water board may set a single tariff for its whole supply area, or it may set a separate tariff for each bulk scheme. Where's the authority? Where do we find the authority for that policy and for the powers which Umgeni Water says it has?
Justice, that's found in the Act. If I may just...
Are you referring to section 33, 1C?
Yes, as well as section 34, because the overall objective was for Umgeni to achieve financial viability. And on that basis, under 34(2)(b) and D, Umgeni may recover its capital, operational, and maintenance costs and recover the costs associated with the repayment of capital from revenues, including subsidies over time. How
And
it
then-
does so.
Sorry, on paragraph 198, the second sentence says, tariffs may be differentiated on the basis of the type and level of service provided. That I would assume refers to what we had discussed on page 337, clause 4, the type of services provided.
Indeed.
Geographic area, there may be a differentiation based on geographic area, customer profile, and may be smooth over time. The differentiation relied upon in this case by Umgeni Water was that essentially CESA was a profit-driven entity as opposed to a municipality. Where do we source that basis for differentiation?
Justice, with respect, the reasoning went further than that. The reasoning was you are CESA is a profit-making entity that we can't offset your losses against other schemes that may be used, as in the case of municipalities. Secondly, the expenditure that we undertook in improving the level of service to you, we are entitled to recoup that, and we're doing so in terms of the Act. So the issue doesn't simply stop at CESA being a profit-making entity. It goes far beyond that. And what also is clear in Umgeni's reasoning is that it did undertake the exercise of establishing exactly what CESA's usage was, when its peak seasons or peak times were, what the operational costs were, and then determining the cost to Umgeni from that.
Yes, I think what I'm asking, Ms. Mahabir, the basis of the differentiation that was applied to CESA, is that sourced from any legislative authority? The reason, the basis, or any legitimate purpose?
The legitimate purpose is to be found in Umgeni's objective of achieving financial viability. And it does so through a meticulous analysis of the services provided to CESA, the use that it enjoys, and the level of service that it enjoys, and whether there is any prospect of Umgeni recovering from any losses that it's in revenue that it suffers through offsetting that by any other scheme. And in the case of CESA, it was unable to do that.
Thank you, Ms. Mahabir.
Ms. Mahabir, do you agree that your client can only come before us in view of the dismissal of the petition earlier on and in view of the fate of the minister's application? Your client can only come before us through your application. And you were asked whether it is competent for us to reconsider that order. I'm interested in the answer to that question.
Yes, Justice Jafta. To the extent that the minister's application for leave to appeal must fail, our application is still alive. And that application is brought on a twofold basis. The court may recall the previous order dismissing Umgeni's application for leave to appeal because it is entitled and empowered to do that under Section 173. Alternatively, on the basis of the conditional direct access application, which is brought, which is on the basis that it is practical and in the interest of justice for the court to hear us.
I'm not quite too sure whether direct access takes you over the line. The question is, the court had made a decision. And now the next question is whether the court is competent to reconsider that decision. If it does, what is the test for reconsideration?
Well, one of the most obvious reasons was there a patent error that was made? And we don't know whether there was or not because of the manner in which Mngeni's application for leave to appeal would have been debated or considered by the court. But if, for us, we believe that the minister's application for leave to appeal does take us over the line. And that the concession that's made by the minister is certainly not fatal, and it's not correct in any event to the basis on which Mngeni or this court is empowered to reconsider the matter from a broad perspective.
What would be the prospects that would entitle the minister to succeed?
If the court is with us on our argument that the concession made by the minister is not as damaging as the minister or as Caesar suggests it is. But moreover, it would be a grave injustice for Mngeni's tariff setting powers to be left where it has been by the SCA without this court, considering within all the context of all the arguments that have been advanced today, whether Mngeni acted incorrectly, irrationally, or otherwise in coming to a wrong decision. We maintain that Mngeni didn't, and it reached a decision not in a manner that singled out Caesar or targeted Caesar, but in a manner that bore in mind a series of factors that were proper and correct.
Finally, I thought the minister was defending only her decision to approve. She was not really advancing Mngeni's case.
That's right. In fact, the minister was supporting Mngeni's case.
Okay. All right, thank you.
Sorry, Chief Justice, you're on mute.
I was saying that I don't have with me a copy of the Public Finance Management Act, and therefore understand my question on that basis. Is agency that you mentioned in section 42 defined in the Act? I understood you to be saying that the minister is the agency alluded to in section 42. Is that agency defined?
Regulatory agency.
Can you hear me, Ms. Mahabir? Maybe you should go back to section 42, the part that makes reference to
but I understand the question, and I'm corrected by my learned friend, Mr. Martin Cielo. Section 42(1)(a) is the authority of the minister.
Yeah. Can you refer to it so that I can refresh my memory? What does it say, that part that you are relying on for the purpose of concluding that the minister is the agency? What does it say?
Under section 42(1)(a), the executive authority within the meaning of the Public Finance Management Act is the...
Yeah, that one is settled. You said it's the Minister of Finance, but there was some reference to agency, I think, agent or agency. What does it say?
I'm being corrected by my learned friend, Mr. Madonsela. Under 42(1)A, the executive authority is the Minister of Water Affairs. Within the
It's not the Minister of Finance.
It's not the Minister of Finance.
Because I was going to ask in relation to agency whether it doesn't perhaps refer to an entity like Umgeni Waters. So now that you say it's the Minister of, what about the Minister of Finance then? Which part of that section refers to him or her?
The Minister of Finance his powers are set out in subsection 5 of section 42, which says that unless approved otherwise by the minister, that's the Minister of Finance, an amendment to a pricing structure which is tabled in Parliament.
If A doesn't refer to him or her anymore, 42 refers.
Yes. So it's the minister under it's the executive authority within the meaning of the Public Finance Management Act.
Is that the Minister of Water Affairs?
Yes. Under the definition of the Act, an executive authority in relation to a national department means a cabinet minister, that a cabinet member who is accountable to Parliament for that department. Under subsection C, in relation to a national public entity means the cabinet member who is accountable to Parliament for that public entity. And then under sub D, in relation to a provincial public entity means the member of the Provincial Executive Council. So in this case, it would be the Minister of Water Affairs within the meaning of the Public Finance Management Act.
Yeah. And if the Minister of Water Affairs and Sanitation did not give the approval required of her in terms of the Public Finance Management Act, what then would be the fate, or ought to be the fate, of the increased tariff? In other words, if her approval has not been secured, if she effectively did not approve as required by law, what submission would you then have to make?
Then the tariff increase can't be implemented without the approval of the minister.
Okay.
But here it was approved as a matter of fact, with the minister bearing in mind the submission, the factors as explained in the submission that was advanced by Umgeni Water.
Okay. Thank you. Thank you, Ms. Mahabir. It looks like my colleagues don't have questions to put to you anymore. Thank you. Judgment is reserved and the court adjourns.
Today's proceedings have concluded. The host will terminate the meeting.